here, we're going to stream live now. All set? Good morning, everyone. This is a meeting of the Massachusetts Gaming Commission. Because we are meeting virtually, we will take a roll call. Good morning, Commissioner Bryan.
Good morning, I'm here.
Good morning, Commissioner Hill.
Good morning, I'm here.
Good morning, Commissioner Skinner.
Good morning.
And good morning, Commissioner Maynard.
Good morning, Madam Chair.
Great. Before we get started, I'm just going to recognize that today is the International Women's Day. And I want to acknowledge that I have the privilege of serving with 2 other women on this 5-member body, public body. So we are represented well here at the Gaming Commission. Of course, we have our leadership with our Executive Director, Karen Wells, and Director of IEB, Loretta Lilios. Our council is here, and another dynamo woman in our legal department, while led by a very capable gentleman, is really supported very wildly by 4 excellent women lawyers. I could go on in terms of our staff, but what's also just really exciting is that the gaming industry continues to expand in terms of female leadership, and this commission watches that in terms of the numbers here in Massachusetts. I also just want to recognize the leadership in Massachusetts. We've had an election that's left us with our white female-dominated Commonwealth. We have 2 women at the helm of the governor's office, Maura Healey and Lieutenant Governor Driscoll. We have, of course, Treasurer Goldberg and Attorney General Andrea Joy Campbell, and we have newly elected State Auditor DeZiglio. And of course, other women are leading in the cabinet. So this is a good year to acknowledge women generally in Massachusetts. But more importantly, I want to also acknowledge the allies. A lot of them are in the form of men who have made sure that women could gain a safe voice around the world so that we could have leadership positions. And that's not lost on any of us. So with that, a little bit outside our lane, but when I look at the number of women in just today's meeting, it's certainly noteworthy. So we'll get started then. And we have quite an agenda. Sterling, we're going to turn to you later in the day, but right now we're going to turn to General Counsel.
Thank you. Good morning, Madam Chair, Commissioners, and all who are joining. We're going to we'll jump right in. I believe the the first item up pertains to Section 152 of the regulations. And Caitlin, are you prepared to jump in on that?
I'm going to kick this right over to Paul. This is an amendment to 205 CMR 152, individuals excluded from gaming and sports wagering. Another collaboration between legal and the IEB. And Paul will walk through the regs, and we are all here for questions. Thanks.
Good morning, Commissioners. The recommended edits to this regulation should be mostly straightforward once you understand the rationale behind them. So I'm going to start with the rationale and then dive into the text. Chapter 23N empowers the Commission to maintain a list of all patrons who are excluded from sports wagering and instructs that no patron on that exclusion list may participate in sports wagering of any kind. Chapter 23K gives the Commission similar statutory authority with respect to gaming, and Section 152 of the regulations is the longstanding regulation implementing that authority in the gaming context. So the reasons that an individual should be excluded from a casino under Chapter 23K, for example, being a known cheat, having violated gaming law, having a reputation which would undermine public confidence in the industry, reflect risks to safety, integrity, or public confidence that carry over to sports wagering as well. And someone engaged in similar misconduct in the sports wagering context would pose comparable risks to gaming. So the proposed amended 205 CMR 152 creates a unified exclusion list where misconduct in either arena leads to exclusion from both. From an administrative standpoint, this has the advantage that the IEB continues using its standard processes, which are also familiar to the gaming licensees. Most of the proposed edits you will see throughout the regulation today simply carry out this overall recommendation. Where the original regulation refers to gaming or gaming facilities, we recommend adding references to sports wagering or sports wagering areas or sports wagering facilities. The reason that we are bringing this to you today, and that it's important that an amended regulation be approved today, is that we would like to have this in place before the Category 3 launch so that the operators are required to exclude people on the exclusion list from mobile sports wagering. Up until this point, anyone on the gaming exclusion list would have been excluded from sports wagering because the only sports wagering taking place in the Commonwealth was at the casinos that these people are physically excluded from. That will change on Friday. The operators have been alerted that this proposed amended regulation is in the pipeline, and we are not concerned about their ability to comply with its substantive requirements. The regulation does impose one administrative duty that we are not sure they can comply with by Friday, and we will be recommending a brief waiver of that administrative requirement. And I'll explain what that is when we get there in the reg. So when we go through the regulation, my plan is to primarily review how each section of the regulation fits into the overall regulatory scheme, and I will call out a few sports wagering related tweaks that deserve close attention. And of course, as always, I'm happy to pause on any particular edit. This seems like a good moment to pause and ask whether there are any questions at a high level before we dive into the reg.
Questions, commissioners? I think you can go right ahead.
All right. So the reg begins on page 5 of your packet. We'll start with section 152.01, scope and authority. As you can see, we added references to the key provisions from chapter 23N. Section 2, maintenance and distribution of the list, describes what information about each individual must appear on the list and requires the Bureau to notify each operator when a new individual is placed on the list. On the next page, section 3, criteria for exclusion, explains why someone may be placed on the list. Originally, this list was mostly taken from chapter 23K. The proposed edits ensure that sports wagering is covered, and they also capture a slightly wider universe of other wagering-related regulations outside the Commonwealth. Based on discussions we had yesterday, I would also like to propose additional language in 152.03(2)D, which is towards the top of page 7 of your packet. After the word jurisdiction, I would recommend include the following language: including, without implied limitation, attempting to corrupt a betting outcome of a sporting event. The purpose of this language is to make it unambiguous that attempting to interfere with a game is misconduct that would lead to exclusion from sports wagering and gaming. And the language corrupt a betting outcome of a sporting event appears in chapter 23N.
Well, could you please repeat that language again?
Of course. After the word jurisdiction, the language would be including, without implied limitation, attempting to corrupt a betting outcome of a sporting event. Section 4.
Paul, can I ask you, elsewhere, is it obviously assumed that if they're disrupting the outcome of the event itself, as opposed to the betting outcome? Like, what's the difference?
Somebody can disrupt a sporting event for reasons that have nothing to do with, that have no nexus to sports wagering. So I would want some language that implies that the misconduct has to be related to sports wagering. Of course, some ways in which somebody could attempt to corrupt an outcome of a sporting event that don't relate to sports wagering might also be covered under conviction of criminal offenses or notorious or unsavory reputation. but somebody who gets into a fight with an athlete in a bar might, if it happens the night before a game, it might be corrupting an outcome of a sporting event, but it would have no nexus to sports wagering.
Right, I was thinking more you bribe an official or a player, that sort of thing. And while you might have an underlying criminal offense, is there other ways that might happen that aren't included in that language? But if you're confident it's covered by the language, then.
Is there any way we can insert that language? Is that, because that's new, right?
It's added to D, right?
Yes. Yes, it developed over the course of discussions yesterday, which is why it does not appear in the packet.
And yeah, I understand it was a new, but I'm just wondering, I didn't write it down, Paul. I have to say, I didn't get it down. So now it's by memory, and my memory isn't great. Can you repeat it again, please?
Including without implied limitation, attempting to corrupt a betting outcome of a sporting event.
Should it say attempting or corrupting? Because are we impliedly not barring the completed act, but only the attempt if we say that?
I think succeeding includes an attempt.
Which one
Okay,
was?
because in the criminal context, it wouldn't. The attempt would be distinct from the successful act.
I'm happy to say attempting to corrupt or corrupting.
I think it's safer that way.
Yeah, I think this. So Commissioner O'Brien, it took me a second to get the relevant provision of the statute up, but for context, the two acts that the two primary acts that the statute uses as examples of conduct that corrupts a betting outcome of a sporting event are abnormal betting activity and match fixing. So I am confident that attempting to bribe an official or a player or threaten
Would be
them
included in that.
is covered. What I left out of these from the statutory language is a limiter for purposes of financial gain. It's conceivable that you could attempt to corrupt sports wagering outcomes for reasons that would have nothing to do with your own personal financial gain. You could want to mess somebody else's bet up, for example. So it is slightly more expansive than it is a. We do have slightly broader coverage for involuntary exclusion.
So I hate to ask you to do this, but could you read it one more time, kind of where we landed?
Of course.
Is it including without limitation, attempting to corrupt or corrupting a betting outcome
Of a sporting event.
of a sporting event? Okay.
Well, I'm going to ask this question, and I'm playing catch up here. It's the outcome of a sporting event, right? That's the word you used, outcome of a sporting event.
A betting outcome.
Betting outcome of a sporting event. Do I have to worry, is that about the Is that just the outcome of the event? Because I don't know what sporting event is. Is that the outcome of the game, or could it be the outcome of a play within the game?
It could be the outcome of a play within the game if betting is offered on that play.
Okay, thank you. Thank you.
Commissioners, are you ready for me to move on to section?
Yeah, I think I was moving on, so thank you, Paul. Thank you so much.
Section 4 establishes the administrative procedure by which someone is placed on the list. To begin with, the Bureau investigates. If there's a decision made to place that person on the list, the Bureau prepares an order to that effect and serves it on the individual. The individual may request a hearing before a hearing officer and appeal an adverse decision before a hearing officer to the commission. There are 2 edits of substance to this section. The first one in paragraph 1 expands the list of whom the entities from whom the Bureau takes referrals for investigations to include sports wagering operators, sports governing bodies, and players associations. The second in paragraph 2A expands the exclusion from casinos to be an exclusion from casinos and from sports wagering. And you will see that theme repeatedly through the rest of this regulation. Section 5 on the next page, placement on the exclusion list pursuant to Chapter 23K, Section 45I is a bit different from everything else that we've been discussing. So rather than addressing integrity, this section deals with problem gambling. Chapter 23K enables you to go to court if you have a family member who is a problem gambler and seek an order barring that person from gambling in casinos. There is no similar provision in Chapter 23N, but the Commission has the power to adopt regulations to combat problem sports wagering. In our view, that power permits the Commission to exclude someone who has been adjudicated a problem gambler under Chapter 23K from sports wagering as well. Section 6 addresses licensees and operators' duties. Throughout this section, once again, all the changes are meant to ensure that this regulation covers sports wagering operators, their physical facilities, and their mobile applications. So going paragraph by paragraph, the duties that this section imposes on operators are 1, monitoring the exclusion list, 2, to the extent that they operate physical facilities, actually excluding individuals on the exclusion list from those facilities, and cooperating with the GEU to that end. 3, to the extent that they operate mobile platforms, keeping individuals on the exclusion list off of their mobile platforms. 4, informing the Commission of individuals whom they believe should be excluded. 5, maintaining a written compliance policy that itself meets certain standards. And Section 6 is not a separate duty. It simply sets out grounds for discipline. Section 5 is the administrative requirement that we are going to ask be waived for a brief period. It is the requirement to maintain a written policy about how to comply and how to keep excluded individuals out is distinct from the requirements to actually comply and keep individuals out. And we don't see a need for the operators to turn around these written plans within the next 36 hours or for Executive Director Wells to approve these written plans within the next 36 hours, given everything else that's going on with Go Live. Again, we are confident, based on our discussions with the operators, that they are prepared to comply with the substantive requirements of the regulations. So after the vote on this regulation, we will be asking for a 1-week waiver of this compliance provision, which will give operators enough time to either get their plans in or request a further waiver as needed, but they will need to come to the Commission at that point.
So Paul, when I was talking with you yesterday, I had some concerns about the waiver, and by the end of it, I was confident with what was in place. But could you elaborate a little bit more on why, to some extent, the approval of this plan is ministerial because it's covered in other regs? I think it should be, made a little bit clearer on the record that this is effectively already in place because of internal controls and other regs. which is why the waiver is more ministerial than anything else.
Of course. 205 CMR 238, I believe it is either subsection 32 or 33. As amended last week, adds language requiring operators' internal controls to exclude people on the involuntary exclusion list from sports wagering. In addition, as I said, waiving this paragraph 5 for a brief period does not waive paragraphs 1 through 4, all of which substantively require these operators to keep people out of their sports wagering operations. The casinos have long been complying with this regulation, and this is, for any of the operators that are going live on Friday, we are not the first state to require involuntary exclusions that they will be operating in, and they are aware that this list is coming, and we've asked them to get ready. We've asked them to get ready to be excluding individuals on the existing exclusion list as of Friday. So we're comfortable with waiving the administrative requirement that they submit a plan which overlaps with the substantive requirements which are covered elsewhere, and otherwise imposes marketing and training requirements that are not as urgent.
Right.
And
This
the
is not-
practicality is the size the body is basically doable by the time they launch. So we have every expectation that it's going to be in effect by the time they launch anyway. Right.
I think, Commissioner O'Brien, could I just clarify? They must exclude.
Mhm.
It's just they don't have, we'd only be lifting
Yep.
the requirement that they have a plan to.
Correct.
comply-
That's what I just wanted that clear on the record so people
Right.
understand. They already have this as part of their internal controls requirement. And so this is almost like another layer that we have in here. So we're giving a ministerial waiver, but the practicality is they have to do it and they have the plan in their internal control. So this is almost like a belt and suspenders reg.
They have to comply, but they don't have to have a written plan. That's the thing. The only thing they don't have to have is that.
Well, but the
written
plan's
plan.
it's already kind of in their internal controls. That's my point. So they already kind of do have a plan. It's just that there's sort of two different places that they need to do it for different reasons. So
That's right. But they have to comply. One thing I want to just note, and Director Lilias and I had this conversation yesterday as well. Unlike the involuntary self-exclusion, the voluntary self-exclusion where the sports wagerer may voluntarily self-exclude from engaging on a sports wagering app, they could still go to the casino. In this case, the involuntary applies to both. And that's an important distinction. It applies to all gaming in Massachusetts. Director Lilios, is that fair? Did I say that correct?
That's right, Chair. And I think the rationale for that is that the voluntary exclusion list requires the individual to make a decision about themselves and what is makes them vulnerable, whereas the criteria for the involuntary list apply equally to wagering in Massachusetts and risks to wagering, regardless of whether it's on the gaming side, the sports wagering side, in person or electronic.
Very good, very helpful. Just a reminder on the voluntary for me. Well, thank you. Paul, or commissioners, do you have other questions? Because Commissioner O'Brien brought up, the practical reality of the waiver that we're going to be asked to provide.
I have a question.
Yes, okay.
I think the waiver makes sense for the reasons stated. My only question is whether that week that's being proposed is enough time for Karen and the rest of the team to review, because that's also a requirement of that same section 5 there.
Did we commit to a week?
We didn't, but that was Paul's proposal.
Yeah.
Just as long as we're factoring in any time that Karen needs to actually turn these around.
Director Lilios, I don't know if you want to shed some light on that because you considered the waiver.
I don't want to speak for Karen here. We thought we could bundle it up carefully for her. And so I think it's doable. And you're right that Commissioner O'Brien about the sort of ministerial aspect of it. So that will be helpful. In fairness, the operators have not had the reg that hopefully you will vote on today. So that will kind of tie it up for us. But it's clear that they're obligated, if you vote to approve this reg, that they would be obligated to keep folks on the list out. There are, I believe, 58 individuals on that list now. It wouldn't hurt, certainly an extra week, 2 weeks, if you're comfortable with that. I'm sure could be put to good use.
I'm fine with 2 weeks. Commissioner Maynard, you're leaning in?
I'm fine with that.
Thank you.
Commissioner O'Brien?
How about 10 days to split the difference? And how about 10 days to split the difference?
That's a Saturday, so
Well,
maybe we could do the
I
20th.
think we'll roll it over to the clear
Yeah, do the 20th,
2 weeks.
do the Monday. Yeah, was that the 20th? They have to get it to you by the 20th?
Well, I guess that's my question. I want to make sure I understand. I'm just pulling my calendar up, the due date that I have to approve it by. So does it need to be approved by the 20th or do they have to submit by the
Or
20th?
submitted?
I think we were contemplating that it would be that they submit. I don't know we were expecting the executive director to turn it around the same exact time frame. I was thinking that
I thought
it's time for them to submit to the commission, if that makes sense. And Paul, correct me if I'm wrong, or anybody else if I'm wrong on that.
I thought it was submit. Could it be the terms of the waiver make that clear too?
I think we can decide that. So let's do this. Let's figure out a date that will be, because what we really are interested in is when the waiver will be lifted, right?
Right.
So that would be when the executive director signs off. So how much time do you think that requires? We want to give the operators enough time to get the plan down. They're getting the reg. And then we need enough time for IEB to review. So what do you think, Karen? I'd like to have the date be when the waiver lifts.
Loretta, do you want to do the 2 weeks?
Yeah, maybe submit within a week.
One at a time, please. Director Lilios?
I'm thinking submit within a week and approved by the second week.
And that's enough time for the operators.
Heather, if you feel differently, I know you've been in touch with the operators on this issue.
Pretty girl.
Samantha, I just want to let you know that you are not muted, so we can hear. Thank you.
So the reg just says submit. We're granting a waiver to 152.065 and it says shall
Oh, it does say
submit.
submit.
So the waiver is for the time to
The
submit. It's the
executive
obligation.
director- The next line, does that inform anything?
And then the ED shall review if approved, note, but like the timing that we're doing the waiver on is the requirement to submit.
Yes.
Okay, so we don't have to worry about
Do
approval.
we have to?
It's just a funny thing to think about, isn't it?
Yeah.
Wouldn't we want to ensure that they've been approved before they actually implement the plan? That's why I was asking
I
about.
think the reg is
follow-up.
written, the reg is written.
Yeah, it says if approved, notice shall be provided to the commission and plan shall be implemented. So notice is given to us prior to implementation, it sounds like.
But it wouldn't be enough for me to know that the operators have submitted their plan. I would also want to know that the executive director has approved the plan for the operators to implement.
Or she's, I think.
Or not approved, and
If approved, if approved seems to, if approved, it sounds as though that's the executive director's approval. I think the reg might just be.
It sounds like.
Hall commoners,
No,
what do
it
you
says
think it
for
means?
approved by the ED.
How can you help us? Maybe this is a good time to just tweak it.
Mhm.
What do you think, Paul?
Um, I- I'm not sure I want to tweak this. I'm not sure tweaking the sequencing in this regulation live within the meeting is the easier
Well,
path, although we can certainly bring something back with more clarity.
Can I ask the question? What if the word review for executive director was approved instead?
Well, I would not want to write that the executive director shall approve the plan. I would want it to be something more like shall review the plan for compliance and determine whether to approve the plan. I think
Right. I mean, she's not going to, I don't want her to just approve it. You're right. So, but the idea is, you hearing the commissioner just wondering about timing here. Are we, Commissioner Skinner's raised the point, not, seems weird to just waive it for submission. If we're so concerned about the plan, is it fine just to have it submitted? Or do we want a next step?
I think if Director Wells and Director Lilios, and I know how much is on them right now, and I do not want to speak to their capacity. If they are comfortable with a given timeline for approval, I think there's nothing wrong with granting a waiver that has two independent elements. One is a submission date and one is an approval date.
Okay, because the third line does say if approved. So there's an assumption that the executive director is reviewing for compliance. So if approved.
It's more than an assumption. There's the language says.
Yes, it is.
Director shall review the plan for compliance.
For compliance, but I think he's saying you don't want to just, because I suggested, replacing review with approved, but then it sounds like she's just rubber stamping it. So we don't want that. So if approved, so can we say is 2 weeks sufficient for the third line to trigger?
I mean, I posed the original question to Karen, and I don't know that Karen has spoken yet in terms of, from her perspective.
No, she's just wondering if it's for approval or submission. I think that's what her question was, right? Karen, go ahead.
I just want to be sure. The other thing I'm looking at is that we have a commission meeting scheduled for the 23rd. So my suggestion is that we have the waiver go through the close of business on the 23rd. So that way, if there is a need for an extension of the waiver, we could do that at the commission meeting. But let's plan that I would approve, on or before the 23rd, and then I can report out at the commission meeting on the 23rd. Does that make sense?
Yeah, I think the 23rd works. And Karen, are you reading that the regulation requires you to review?
Yeah.
Compliance, and that the next line, it's your approval?
Yeah, I think so. Right.
That is how we've been reading the regulation.
That's what I gathered. So you would come and let us know if there's an approval process. And if there is something in the interim, you'd have them tweak their plan and come back so that hopefully everybody's in compliance by the 23rd.
Correct.
Does that make sense, commissioners? Are we good with that? Okay.
All right.
So anything else on, if we could just go back up, with respect to the changes that are being proposed, any concerns on this particular section, never mind the waiver issue on 1 through 4? And again, to be clear, because it's such an important provision, this does not waive the obligation for any operator to keep to restrict anyone on this list of 58 names from engaging in online sports wagering or retail sports wagering, and of course, casino play. And I think all 5 of us would say this is a very critical provision. So the waiver should not be confused in any way. I think all of us have stressed how important it is to make sure that those who may not wager or not eligible to wager cannot wager. Hi, Commissioner Hill.
Just agreeing with you, Madam Chair.
Well, excellent. Thank you. Yeah, so that's the bottom line. All right. So are we good with the reg as it is then? This would be a chance to clarify if you want any clarifying.
Yeah. So, Madam Chair, and the Paul and the other attorneys that were on the call with me yesterday, we had a conversation about addressing conduct that some of the Players Association reps mentioned in terms of threatening conduct to either the players, their families, refs, that sort of thing. Can you remind me what section we were talking about?
Yes, that was in section 3, criteria for exclusion.
Yeah.
So that's 03?
That's 03, runs from pages 6 to 7 of the packet.
And which number? 03 subsection?
There are several provisions that conduct could come under. Our recommended additional language that we discussed earlier, including without implied limitation, attempting to corrupt or corrupting a betting outcome of a sporting event.
Could you just say again the subsection, Paul? I'm sorry.
We would insert that 2D.
That was D. Yeah.
2D or 2D?
2D.
Yes, there it is. Okay, and where else?
So
was there another?
So that's I had on whether we needed any more specific language in terms of people are committing threats to players, their families, coaches, refs, that sort of thing. I wanted to make sure that that kind of conduct, that people were on notice that that kind of conduct could result in exclusion.
I think
so. I just wanted to have a conversation with us.
I think that's what Paul's language that we talked about earlier was contemplating, his addition to 0.03 2D.
So corrupting would be even making a threat to a player, player's family, that sort of thing. That's
physical threat.
If you feel that that language covers it, I just wanted to make sure there was language in there that covered that kind of scenario.
I read the phrase corrupt a betting outcome of a sporting event in the statute to cover any attempt to improperly affect the outcome of a sporting event, and that would include threats, that would include bribes, that would include actually doing the physical harm that one is threatened.
A threat to physical harm.
So, so I guess my hypothetical: what if it came after the event? What if the threats to the player, the player's family, the ref, whatever, came after the outcome? Would it still be covered under our statute, under this reg?
It said outcome of the sporting event, if I remember correctly. So I asked on one side, you're asking on the other, which is a really important question, because it might be intended to corrupt going forward.
A future, right?
It could be, or it could just be. Can it be linked to not having any influence, or is that outside our?
Well, yeah, and then we talked about harassment, et cetera. Do you need 2 or more acts as opposed to a single act? As you know.
If I can jump in a minute on this, so that's I was thinking about that as well, Commissioner O'Brien, about the timing of it, right? Because if it precedes the event and there's an incident that can be linked to, trying to affect the outcome, these matters, even in the casino context that we've been dealing with over these years, they're intensely fact specific. I can't say definitively to your question, but it would be a very fact-specific inquiry that the IEB would perform. If one area of guidance that we have gotten from the commission in the past has been where there are other governmental agencies that may have a role in the matter, that this tool of the exclusion list, we shouldn't feel like this is the only tool we have. So for instance, in the context of leaving minors in the cars, for instance, there's been a directive from the commission that, we have Department of Children and Families, we have our state police GEU who are mandated reporters, to some extent there's reliance on that. To the extent, which is not to say that we don't exclude individuals from unattended minors, we do. We also, there's a statutory requirement that security inspect the garages specifically to look on unattended minors. So we'll rely on these other kinds of activities and agencies. With the term threats, right, there's, the vernacular of what a threat is, but there's also threat that it is a crime, and there are elements of the crime, and there are, law enforcement agencies that have an obligation to review incidents like that we could refer to law enforcement agencies. So I just wanted to give that context to this, that the exclusion list is a very useful tool. To the extent that we might be applying it to retroactive conduct for a punitive piece, I'd suggest, that may not be the right use of the tool, that the tool that we're largely trying to utilize is to maintain integrity of gaming, maintain safety of individuals. So if we look at an incident and safety is an issue, that will be something that we look at carefully, right? So I hope I'm
But Loretta, this entire subsection is past conduct. Like 03 is all based on past conduct. And so if the consensus is that we feel the language sufficiently addresses it and we're willing to come back, if we find a situation where it doesn't, we can move on. But 03 is all past conduct. And so, and having prosecuted threats cases, you and I both know that they can be difficult sometimes to prove. This is now going to be across social media potentially, which is a whole other beast that raises jurisdictional problems for law enforcement, that sort of thing. So I want to put it out there. That was the biggest takeaway I took from the Players Association meeting. So if we are comfortable that we have sufficient protections I'm fine. I just want to be all on the same page that if we find we're not, that this is something we circle back to in the near future.
Yeah. I think that we have the hook in there for threatening type conduct. It's always, using these are past conduct. It's always using past conduct to predict future conduct, right?
Right. Or act as a deterrent, right?
It would still be a very fact-specific inquiry that we would have to utilize.
Right.
With that said, I think initially the question was, Commissioner O'Brien, is the language corruption sufficient to capture all types of actions that the Players Association raised with us, with respect to family members, with respect to officials, with respect to the athletes themselves? And I'm hearing, Paul, that you're comfortable with that. The only thing with this reg, it will never show we've had this discussion. In 10 years, unless you come back to our meeting. And so,
I wonder if there's a way
to the safety of the patrons, employees, or others. I'm just wondering if there's any place to capture family
players,
members,
referees,
and
Chair,
articulate that.
I don't know if this helps, but in looking at 1E, that specifically discusses, presenting the potential of injurious threat to the interests of the Commonwealth.
Could you tell me the exact section, please? Because I'm having trouble following
Sure.
the 1D and this D. Yeah.
031.
031D.
yeah, 1E. This is the
Okay,
section we were
1E.
talking about yesterday.
Yeah.
Is whether
So, I'm-
the Commonwealth's interest includes that,
And then,
which
and
I
then we
would
go
like to say
down
it
and
does.
then we go down and we do mention employees and the players, but in a different provision. I just wonder if we should be, just lost that.
Yeah, it says presents the potential of injurious threat to the interests of the Commonwealth in a gaming establishment, a sports wagering area, a sports wagering facility, or a sports wagering platform. I was wondering if there's any language that goes beyond that in terms of, you know, integrity or safety of the sporting event and, you know, the players, their families. Is there some way to add language in there that makes it clear that that is part of the Commonwealth's, what we want to protect from potential injurious threats?
That's up there.
Because those are very specific to, you know, building, sub area within the building, you know, another facility building, and then an online platform. So it would have to be interpreted as impacting those.
Areas, but I don't think we,
Right. So I don't know if it's clear enough in there. And to your point, this conversation might not be enough. So is there language that's necessary to make that clear?
I don't want to tweak the language gaming establishment because I think that is drawn from chapter 23K. But I
No,
have
I'm thinking more adding to the sequence.
Well, I would also have no problem with replacing sports wagering area, sports wagering facility, or sports wagering platform with in sporting or in the sports wagering industry, or in sporting events or in the sports wagering industry.
Do we add that as opposed to striking the language that you put in there already?
What if we just said, or the integrity and safety of sports wagering in the Commonwealth?
Well, I guess what I'm trying to get at is are we interpreting wagering to include all of the players in the event itself?
Right. So for the moment, what I would like to say is that I think any criminal act that relates to sports wagering is likely covered under 1B, violating or conspiring to violate laws relating to gaming or sports wagering. So I'm not worried about coverage for something that rises to the level of criminal harassment or criminal threats. For if somebody threatens a player or somebody connected to a player for conduct that is already for conduct in a game that has already taken place. I'm comfortable that we have enough coverage to move forward there. I'm also
that would
comfortable that we
include
have
family
coverage.
members and officials, right, Paul? And
If there
officials.
is a nexus to sports wagering, I would say it is a law relating to sports wagering.
Okay, thank you.
For conduct that is intended to influence the outcome of a future game, I'm perfectly comfortable that the corrupt or corrupting, abetting outcome language covers us. We can certainly workshop all of this in the coming weeks as this regulation comes back for final promulgation.
Well, and I'm wondering, do we reach out to the Players Association? Because I know they had been directed by the legislature to work with us in terms of the regs, you know, and so I'm wondering if a reach out specifically on whether they have any suggested language that we could consider.
We can do that.
Yeah, I would certainly be interested in hearing their feedback.
Yeah.
Okay, so that we hadn't gotten through the whole. We went back on that. We were at a provision where employee was mentioned. Oh.
We were I think we were at the end
The
of section
2C.
6. Oh,
2C mentions the patrons, employees, or others, Madam Chair.
Oh,
If that's what you're
thank
looking
you.
for.
Yeah, so whether the individuals can pose a clear threat to the safety of the patrons, employees, or others on or near the premises of a gaming establishment. That's the patrons and employees of the gaming establishment,
Mhm.
the patrons.
Yeah, it's funny, platform is not in there and that one.
Platform.
that paragraph is meant to deal with physical
Right.
establishments.
To deal with, I'm sorry?
Physical establishments.
That's what I figured, the physical establishment, but I'll tell you what I'm thinking about is the Players Association where the individuals are at, and I know we don't have control of the venues themselves, but they are threatening players or their family members who are actually at a sporting event, or the officials at the sporting event.
Mhm.
They did say that, and that commissioners,
Yeah.
you can help me out.
Yeah.
Commissioner Maynard, do you want to remind us?
No, that was my memory. And to Commissioner O'Brien's point, I'm not as eloquent as you are, Commissioner O'Brien, but, you know, even if the whistle stopped and the game's over, if someone shouts down a player's family member, I would want that call to be interpreted to come in and allow us to put that person on the exclusion list. And so if the language does that, great, but that's how I interpreted what they said too. And as to affecting a future game, like in a tournament or something, I think that would come right back in as written, as you said. So the commission really wants to focus and make sure that nobody's put in harm's way. And so that's.
And of course, Paul's
my
going to
memory.
say, well, we don't have really jurisdiction over every person at a sporting event, only those who are engaging in sports wagering. And that's hard to know in real life. So I think we have limits on our own jurisdiction, but to the extent we can think about that creatively.
Madam Chair, that would be to place them on the exclusion list, right? Like
Right.
that is the limit.
Place them on, that's good. That's a good, so there we go.
Right.
Can we do that? And is it any patron? Are we okay with that? If it's just the Commissioner Hill, I'm thinking of you, Commissioner Skinner, any, irate fan?
Madam Chair,
Yes,
if I can just go back in time to the letter that was written to us.
thank
There's
you.
there's actually specific language that I think would be helpful. Of course, I would need help on where we would put the language. But it says, if the commission determines reports of violence, threats, or other acts of intimidation against players, coaches, officials, or their families to be credible, or others prohibited conduct as defined in CMR, blah, 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 said determination shall constitute sufficient cause for exclusion from a sporting event pursuant to the provisions of section 11B. So I think that at least gives us a little bit of a starting point.
So they actually say exclusion from a sporting event versus exclusion from the sports wagering.
And we could massage the language to,
We could do that.
but I mean, the language is a good starting point.
Yeah,
Question is where we read.
because I don't know, Commissioner Skinner, you've got your mute off too, if you want to contribute. I didn't know if we could really do exactly what the Players Association asked for, but.
Yeah, I'm reminded of my comments at the time. I was a little skeptical as to whether or not the commission had the authority to exclude a patron from the sporting arena.
Yeah.
But I do think there is wide authority in excluding an individual from sports wagering in Massachusetts for any of the reasons that have already been outlined in response to, not only the commission and the Commonwealth's interests, but the interests of the Players Association. I think 15204 opens the door for us to do that. To your point, Madam Chair, would we know about any incidents occurring in an arena in Massachusetts? We wouldn't necessarily, but this invites the Players Association to submit a request for an investigation. Maybe that's not the right terminology, but to notify the commission of such an issue or incident, and IEB has discretion to investigate that on its own accord, and potentially in conjunction with the Players Association. So I think 15204 kind of, spells that out, that process, what that process might look like a little bit.
So a lot of input, Paul, but it really was a very important roundtable. And I think, I don't know if we talked so much at that time about the involuntary self-exclusion list, but we knew that we wanted to be responsive. So here we are.
So we would welcome any referrals from the Players Association, which is why we made a point of adding that in 152.041. I think I think everyone is correct that we do want to know about credible, serious threats to players or anyone connected to players. And but the practical realities mean that some of this conduct is going to have to be brought to us as opposed to being something that can be proactively sought out and identified. I really do think that the sufficiently credible threats are going to come under 152.03(1)(b, violating laws relating to sports wagering, and anything that's any threats that are forward-looking will be covered under the language that we proposed adding earlier. And beyond that, we really would welcome further feedback. I would be happy to take a look at the language supplied by the Players Association. We would welcome further feedback from all stakeholders and can tweak this as we move towards final promulgation.
So Paul, can I throw another thing for you to consider, which would be when you're looking at 152.03(2)(c), whether you also add or a sporting event, because that would then enable IEB to consider conduct that you talked about, screaming at someone's family members as they're leaving, related, it's not that we necessarily have to proactively police it so much as it specifically says IEB can take that into consideration.
I'll say that the reason that I didn't use 032C as my jumping off point for the corrupting language that I proposed is that I thought poses a clear threat to safety was probably a higher bar than the commission wanted to impose for some of this threatening conduct, because the real question is how it's perceived by the recipient, not how the commission or the IEB perceives the clarity of the threat. But I can certainly take a look at incorporating something into 02C.
So what I'm thinking of is, because I see a disconnect between past events and conduct. And so I'm wondering if having it in multiple places makes it clear what the conduct is that's appropriately considered by IEB. If you're telling me you think that it somehow diminishes the ability to use it and the corrupt practices, the conduct part, then I get that. But it would seem to me that putting it in C might not diminish, but would just add to IEB's discretion.
Right. I'm concerned.
I don't want to take up more of the time meeting time. I talked a lot.
I don't have other plans, commissioners.
Yeah.
I have a hard stop at 2:15, so maybe I'm being a little selfish.
Why don't we say that this is coming back? Paul's heard from us, but before we go, Commissioner Hill, on the Players Association letter, thank you for bringing it up onto your computer. Do you still have it? Because there was a second proposal, but I don't think it's applicable here. I can't remember.
They had also proposed language, said prohibited conduct includes any statement, action, and other communication intended to influence, manipulate, or control a betting outcome of a sporting contest or of any individual occurrence or performance in a sporting contest in exchange for financial gain or to avoid financial or physical harm. Prohibited conduct includes statements, actions, and communications made to a covered person by a third party, such as a family member or through social media, And prohibited conduct does not include statement, actions, or communications made or sanctioned by a team or sports governing body. That was the second
So-
proposal they used for what prohibited conduct would be.
I think the Players Association requests are on maybe legal's list to return to. That's a general provision that's actually kind of caught here, generally, right, Paul? But we should think about whether we need to incorporate that in a different reg as well. And I'm turning to Todd, but I don't think we need to put anyone on the spot on that, but I think this should be on the continuing list of matters for us to be thinking about. Okay. Caitlin, I'm turning.
I was just going to say,
Caitlin on the ordinance.
absolutely, we can take, and we have looked at that letter as we've been moving through, but I think totally fair to take another look and see if their comments could be incorporated into an existing reg or a new reg would make sense.
Oh, yeah, okay. But I do hear that's not so different than, I think if Paul's right, that corruption language is so general that it's going to capture those kinds of general threats that are made to to family members and to refs. That works for me, but you're going to take a look at it. And we'll circle back. When will this come back to us again? The 23rd.
We don't have the exact date, but this will be on if it's promulgated by emergency today, it will be filed tomorrow, and then it's the 60 to 90 days for it to come back and be finally in effect. So,
well, we've got some protection that we know of clearly based on today's discussion, should we so vote. Okay, anything else as we go through? We should probably go through the rest, right? Oh,
Yes, I believe we left off at the end of section 6. So we would pick back up on page 10 with section 7.
section 7.
There are no substantive changes here. This sets out an administrative process for an individual to petition to be removed from the exclusion list.
Yeah.
Section 8, forfeiture of winnings, ensures that individuals on the exclusion list who nonetheless manage to place bets or wager in casinos do not collect their winnings or recover their losses. Originally, all such winnings went to the Gaming Revenue Fund. Now winnings go either to the Gaming Revenue Fund or the Sports Wagering Fund, depending on how they were won. Finally, Section 9, sanctions against a gaming or sports wagering licensee. Paragraph 1 of this section establishes the substantive standard for a violation of 152. You'll see a number of the changes that you would expect to ensure that this section covers prohibited sports wagering as well as gaming. Paragraphs 2 to 4 set out a procedure for disciplining gaming licensees. Rather than adapting those paragraphs for sports wagering licensees or rewriting the procedural parts of the statute altogether, we recommend simply adding a new paragraph 5 that you will see on page 13 of your packet that simply refers to 205 CMR 232, the umbrella sports wagering discipline regulation for the procedures to be followed in disciplining a sports wagering operator.
That is it.
That is it.
Questions? Thank you, Commissioner O'Brien, for bringing up the Players Association piece. Critically important. Other comments or questions for Paul and the legal team? I'm hearing none, Paul. So we do have to think about the waiver. And we have to think about putting this into emergency effect now. I have a motion.
Madam Chair, I move that the commission approve the small business impact statement in the draft of 205 CMR 152 as included in the commissioner's packet and further discussed and edited here today. There was a small tweak. And I move that staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth by emergency and thereafter to begin the regulation promulgation process. I further move staff be authorized to modify chapter or section, numbers or titles, to file additional regulation sections as reserved, or make any other administrative changes as necessary to execute the regulation promulgation process.
Second.
Any questions or edits on that motion? Okay, Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard,
Aye.
and I vote yes. Good work. So 5-0 on that. Now with respect to the waiver.
Madam Chair, I move that in accordance with 205 CMR 202.023, the commission issue a waiver to all licensed sports wagering operators from the requirements of 205 CMR 152.065 through close of business on March 23rd, 2023, as granting the waiver meets the requirements specified in 205 CMR 102.034 and is consistent with the purposes of General Law, Chapter 23N.
Second.
Thank you, Commissioner Hill. All right, any questions or edits? Okay, Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard,
Aye.
and I vote yes. So 5-0 on that waiver. And thank you for thoughtful work on that. I think we can just pause for a second. I should have at the beginning of the meeting really called to order. Just a reminder, today remains March 8th, Wednesday, and it is public meeting number 441. So for the records, thank you. So now we're going to turn to the next item on the agenda. General Counsel Grossman, we have 203 CMR 138 to consider. And on our packet, I think we're moving toward page, I'm on page 16. And for the record, it's 16 of 1,089.
Good morning, Madam Chair and Commissioners. I can take this one for you today. I just have a procedural matter for you here. I'm sure you recall that last Thursday on March 2nd, you voted to finalize a set of 5 regulations, just to remind you what those are, and they are in your packet. It was 205 CMR 138, Uniform Standards of Accounting Procedures and Internal Controls, 205 CMR 238, Additional Uniform Standards of Accounting Procedures and Internal Controls for Sports Wagering, 247 Uniform Standards of Sports Wagering, 248 Sports Wagering Account Management, and 254 Temporary Prohibitions from Sports Wagering. So those 5 regulations had been initially filed by emergency several months ago, and they had gone through the formal promulgation process, including a public comment period and public hearing. And we had, of course, worked through those comments and adopted some. And your vote last week was the conclusion of that process to finalize the promulgation process. So just a little bit of background here. Regulations are published by the Secretary of State in the Mass Register on a biweekly schedule. While emergency regulations go into effect immediately upon filing, final regulations don't go into effect until they are published in the register. And so because of where we fell in that biweekly publication timeline, we realized that if we had filed these final regulations last week, they wouldn't have become effective until March 17th. Which means that the initial emergencies that were filed in December would have been the versions in effect upon launch in that week timeframe between the 10th and the 17th. So we're here today just again on a procedural issue, just to have the commission approve those regulations for an emergency filing, which means that we would file those by emergency tomorrow. They would go into effect immediately, and they would replace those previous emergency filings from December. And then we would also be seeking approval, which essentially would be the same approval you made last week, to file the final versions in the coming weeks that would complete the formal promulgation process. And again, really just a formality to ensure that the updated regulations that you worked so tirelessly on would be in place on the 10th for launch.
First off, thank you, Carrie, for reminding us of the complexities of the regulatory scheme and framework that the team has been working on since we were given this assignment August 1st, 2022 to stand up sports wagering. The framework is complex and you've navigated it beautifully. And so today, I think everyone's clear as to why we need to take action today to ensure that we're covered during this interim period. This has been what's the number of regulations, Carrie, overall? Do you
Oh my gosh. I had counted a while ago the individual sections, and it was, when I last counted, I think it was close to 200. So it must be more now.
Yeah. I think it's probably creeped up close to 20s anyway. Any questions, commissioners, for Carrie or Todd? Okay. You're going to need a vote for us. Do we have a motion?
Madam Chair, I move that the commission authorize staff to take the steps necessary to file the required documentation with the Secretary of the Commonwealth by emergency for the following regulations as included in the commissioner's packet and as discussed and approved on March 2nd, 2023, and to thereafter take the steps necessary to file the required documentation with the Secretary of the Commonwealth to finalize the regulation promulgation process for 205 CMR 138, 205 CMR 238, 205 CMR 247, 205 CMR 248, and 205 CMR 254.
Thank you, commissioners. Any
Was it
questions?
254 or 252?
254.
254, okay.
Any other questions?
No, second.
Commissioner Maynard seconded, so
Oh,
we're all
sorry.
set. No problem. We got the question was answered. Any other questions or edits? Okay. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard,
Aye.
and I vote yes, 5-0. So all set on that work. Thank you.
Thank you.
Thank you, Carrie. Have a good rest of the day. I don't know if you're sticking around for the House rules or not. So thank you.
I'll be watching. Yes.
Thank you so much. I may call on you too, Carrie. Let's see.
Madam Chair?
Yeah.
Madam
Okay,
Chair,
so yes,
can I ask for a 5-minute break, please?
I was just going to make that inquiry. So we do have a good chunk of business. It's 11:54. We could come back around noon. Are we just having a short break now, or do people want a longer break?
So I actually have a hard stop at 2:15, 2:20 myself. So I don't know if it makes sense to do like a 15-20 minute break to eat something now. I throw that out there for consideration.
And then have a good 2 hours, Commissioner O'Brien.
Yeah, or I have to hop off.
That works for me.
Yep, that's fine.
Does that sound good to you, Commissioner Skinner? Is that what you said? Okay, excellent. Commissioner Maynard. All right, so Commissioner Hill, good idea. It is for the public, it's right now 11:55. We'll reconvene 12:15. Okay, thanks so much and great work. What's that, Dave?
All set.
Thanks, Dave. So we are returning to the convening of a Massachusetts Gaming Commission meeting, March 8th. We're holding this meeting virtually, so we'll roll call. Good afternoon, Commissioner O'Brien.
Good afternoon, I'm here.
Good afternoon, Commissioner Hill.
Hello, I'm here.
Good afternoon, Commissioner Skinner.
Second.
You had it.
Good afternoon.
Good afternoon, and good afternoon, Commissioner Maynard.
Good afternoon, I'm here.
Okay, we're all set to go then. Again, public meeting number 441, and we are turning to item now, item 3 on the agenda. And I'm going to turn to Director of Sports Wagering, Bruce Band, who will introduce his team.
Trying to get unmuted there. Okay.
Do you want to make the introduction, Bruce?
Yes. On this for the house rules.
Yeah.
Sterling Carpenter will be the operations manager. Will be carrying out through the house rules on this. Sterling.
Thank you, Bruce. Good afternoon, Chair and Commissioners.
Good afternoon.
Today, we're bringing to you the house rules from the 6 licensees that will be hopefully starting on March 10th. And with that, I'd like to introduce some of the subjects in which we went over. So pursuant to 205 CMR 247, subsection 2, subsection 1, the sports wagering operator shall adopt comprehensive house rules for sports wagering. The sports wagering operator shall not conduct sports wagering until the commission has approved the house rules, and the sports wagering operator shall not conduct sports wagering in a manner inconsistent with approved house rules. The Category 3 tethered and untethered licensees of the Commonwealth have submitted their house rules for approval by the commission, and I have reviewed each of the submissions for compliance with the regulations governing the required content of house rules, which is set forth in 205 CMR 247, subsection 2, subsection 3. As listed in the memo sent to the commissioners, there are sections A through P in which the house rules need to address, and they were all reviewed by the sports division for compliance, and most all have complied with the areas, but there are several sections in which the house rules language in which we want to bring to the commissioner's attention. So with that said, I would like to skip down to our important observations, in that an operator has listed a request for rounding change from payoffs up or down. The sports division.
Sterling, could I interrupt just briefly?
Absolutely.
We have a really large packet today,
Mm-hmm.
and I know that you had a memorandum for us, but I want to see what page you're going to direct us to first. Do you have it? I've got.
It's 171, Madam Chair.
Thank you. I'm scrolling through. I appreciate it. Let me find 171. See if my yeah, my let's see if we can do it. Okay. Let's just give me a second to scroll through. For some
Absolutely.
reason, on some reason, I'm not able to change the page or find it, so I'm just scrolling through, which is a challenge for me of working. There we go. I'm much closer now. All right. I've got the rounding. Excellent. Thank you.
So the sports division expressed great concern over this request by the operator and would like to respond with a denial of the following procedure unless they wish to always round up in the patron's favor. Of course, it is up to the commission to approve all house rules, but in this house rule, they are asking that for any customer that would receive 1 cent or 2 cent in their payout, that they would be rounding down to 0 cents. And so on 3 and 4 cents, they would round up to 5, 6 and 7 round down to 5, and then 8 and 9 round up to 10. If they wish to continue to do the rounding and want to always round up in the favor of the patrons, we don't see a problem with that. But for not providing the accurate amount of money to the patron and rounding down, we would not recommend that be accepted by the commission. I'll
So let's
pause there
pause.
for.
Yeah, let's pause there and have a discussion, Sterl.
Yep.
Commissioners, so this is a request somewhat familiar in the gaming world. Commissioner O'Brien, you remember this probably with
Yeah.
respect to the casino and
The coin.
the coins. And I think that might be, Sterl, a little bit of your memory as you were assessing this, thinking about at least the commission in its earlier composition was concerned about the idea of rounding down. So commissioners, let's turn to Commissioner Hill.
So in my opinion, I would not agree with what's being proposed under their house rules of rounding down. If I had my way, we wouldn't be rounding at all. But if we are going to be allowing it, we're going to be rounding up only, not rounding down. So my hope is that we can work with this provider and let them know that we will not be rounding down. I hope that's how we feel as a commission, but certainly how I feel individually.
Okay, Commissioner Skinner.
I agree with Commissioner Hill. Patron is entitled to every cent of their winnings.
Commissioner Maynard.
From the beginning of this process, as you said, August 1st, I've looked at this in my head, as a patron-centered process, and a patron expects every penny that they put in to come out. And so I agree with Commissioner Skinner, and I agree with Commissioner Hill.
Okay, and I'm guessing Commissioner O'Brien, what your thoughts are.
Yeah, I have no problem if they want to do it to the penny. If it's too cumbersome and they need to change the practice for expediency, it has to be rounded up in the patron's favor.
I agree with that entirely. I'm old school. If they're owed a penny, they get that penny. And that penny is worth a lot when you start saving them up. So I think you've got the answer on that one, Sterl. I think in terms of Commissioner O'Brien, does anybody object if they round up? Is there any policy concern we have there? Commissioner Skinner.
No, sorry. I don't have any concern with the operator rounding up in the patron's favor.
Agreed.
Okay, Commissioner Maynard, you're in agreement too?
Agreed.
Okay, there.
Okay, we will reach out to that operator and inform them of the decision. Second point, so in your submission, it was noted in the house rules of each individual operator's discussion on parlay related rules. I outlined this section because the detail between 2 sentences from one operator to 168 times being seen in one submission alone gives us the range of how detailed to how simplified the parlay related rules can be. So I, as the reviewer, understood all of the submissions parlay related rules. With that said, if it was noted by any commissioner, if they needed to expand on any parlay related rules, or if there is some way that they want to have any of them addressed, you guys can make those concerns known today. But that was just it was a recurring theme, and this was just one of those sections where the answer to a question on the regulation was either very brief all the way to very extensive between operators.
Commissioners, I think operators have taken different approaches. What do you think, Commissioner Hill?
I think Commissioner O'Brien wanted to opine first, so I would yield to her.
I just had a quick question. When I was getting briefed on this, Sterl, you had mentioned that everyone uses the term round robin except for FanDuel because they do the same kind of bet, but they just don't call it that.
Correct.
So my only concern with that is confusion on the part of the consumer. If everybody else is calling that type of bet a round robin, do we want FanDuel to use the same terminology, or is that going to create confusion because their app doesn't call it that?
Good point, though. Yes, exactly. They have provided that when I asked specifically not addressing the round robin that they do, but they consider it just a tiered parlay. That's a good question. Maybe FanDuel would be able to provide us some clarity, or
do we say AKA, around, otherwise known as a round robin, or like, I don't know. I might be creating more confusion, but.
Commissioner O'Brien, can I add to this a little bit?
Yes, Commissioner Hill.
So as someone who used to bet, I know what a round robin is. And I think most of the consumers who are bettors know what the round robin is. I saw that as well as I was going through the rules. And I actually didn't see any issue with any of the language of any of the house rules that were put forth. A round robin is used quite frequently, actually, in the betting world. So I don't think a consumer would be mixed up. That's just one person's opinion. Sterl, I don't know if you feel the same.
We have someone who's chimed in, and Andrew, I'm forgetting your full last name, so you're going to have to help me.
Yes.
Yeah.
Thank you. Andrew Winchell from FanDuel. Yeah, I think just a point of clarity is I think there might have been some confusion on our end about that issue where we didn't, specifically reference the term round robin. We expect them to settle in the same way that our other parlays do settle. So that's why we don't have specific house rules related to them. But if it was a request of the commission to include a line to reference the existence of round robins in our house rules, and just to say that they settle in the same way that our standard parlays settle, that would not be an issue for us.
Commissioner O'Brien, does that kind of
Yeah,
answer?
if I think that might help, because then if anybody is not as sophisticated as Commissioner Hill or others on this call, that if that's the term they were looking for, then at least they could look in and say, okay, it's going to be dealt with that one. I think that would solve it for me.
So just as a procedural matter, this sounds like an edit to the proposed rule. So I'd like, I don't know, Todd, I'm going to ask that you keep track of this because we are going to be voting on these house rules at the end. So it sounds as though there's Mr. Winchell is offering a slight edit to clarify this. And I presume house rules, I don't know what the process is going forward, but they're always going to be subject to amendment and then our ultimate approval. But I'd like to get this one done for today. So what language would be suggested? The AKA round robin for the tier 2, is that sufficient, Mr. Winchell, or is there something?
He indicated they could put another definition sort of round robin in there. I think if you want to repeat the language.
That's what I thought.
Yeah, I think the line would be something, I'm looking at our section on parlays right now. We would add probably just another bullet saying, FanDuel offers round robins, which are settled in the same format as parlays, as the rest of the parlays.
Commissioners and Sterl, what do you think of that addition? Sterl, do you Do you think that helps to
I
clarify?
think it would clarify to the customer that there are that option and that there are round robins, even though FanDuel calls them a parlay. Yes.
Okay. So Todd, you noted that one for us, please. Thanks so much. Okay. Now I'm going to turn back. Commissioner Hill, did you have another point other than the round robin that Commissioner O'Brien brought up?
No, I was just also suggesting, I went through the rules and I was happy with the language of all of the parlay language of all the rules that were put forth.
Excellent. Anybody else have any observation? Commissioner Skinner?
I had a question. When we promulgated the regulation and required the parlay wager related rules to be included in the house rules, what is it that we contemplated? And is with the range of detail provided from operator to operator, Sterl, I guess I'll direct this question to you. I mean, is there any information that's glaringly omitted from one operator over the others that would be necessary for the patron to understand what to expect if there is a concern around their parlay wager?
So not glaringly omitted by any operator. I just wanted to bring to your attention the differences in which each operator answers the parlay. So somebody placing a wager on DraftKings might have a ton of information on parlays, whereas somebody and another operator might have just several lines discussing parlays. There is no set language for them per se. So I had to review each one of them, and they do answer the question of parlay wagering rules. So yes, I feel their rules are able to be approved for this section. I just wanted to bring it to the point that some operators go into great detail for their patrons on every single scenario in which a parlay can be changed, voided, all the different rules. So, yes.
And Commissioner O'Brien highlighted a particular area that was confusing for her. Did you find, and I'm guessing the answer is no, based on your prior response, your response to my prior question rather, did you find any issues that you thought needed further clarification in what was provided, even if it wasn't in such great detail? The things that might strike you as just needing further mention or elaborate, needing to be elaborated on a little bit more clearly.
Yeah. So the problem being is I'm very familiar with all the wagers. So I would ask others, is it okay if they were just explained in a brevity, right? And in which case, I believe that they are all addressed, some, although might have questions. All operators can then also take questions by their patrons, right? So if further down the line, we feel that there are many patrons asking us questions on a certain operator, not going into enough detail for them, the subject could always be revisited. But at this point, I do not see a problem with the rules now.
Okay, and that's a good segue into my next question. It doesn't, it's not just limited to the house rules, the parlay wager section in your memo, just across the board, for things that you haven't even identified for the commission in your memo. What is the process whereby, should the commission receive a complaint, IAB receive a complaint, or a concern from a patron? What's the pathway to getting that matter some attention and if necessary, a revision of the house rules for any operator?
So a great point there. What I would say is we as the sports division requested exact language and actually forwarded the exact language for all of our licensees to use in regards to sections I and J. And in section I is methods in contacting a sports wagering operator for questions and complaints. But also that section says how complaints are resolved and how the patron may submit a complaint to the commission. We gave specific areas in which we can be contacted. We can be contacted via mail, via email, via hotline, and all of those, the entire language has been submitted to the licensees and placed in everyone's house rules. So if anyone has a question, they know how to get it to us, and I will be immediately addressing every single request that comes in with any problem. So if there is a problem that we have not foreseen, we will be hearing about it, and the commission has the right to ask for revisions to the house rules at any given time.
And that process you just described that the sports wagering division undertakes, is that limited to the review of complaints coming directly from a patron? In other words, is there an opportunity for audit of any complaints that go from a patron to the operator, but don't necessarily rise to the level of, having the patron file a complaint directly with the commission? And I ask that because I think it would be important for the commission to be informed as to, the frequency of a certain kind of complaint, so that we can then reevaluate, our steps and requirements, whether it pertains to house rules or anything else, quite frankly.
Absolutely, and yes, correct. They have a reporting. It's in our reporting. Now, I apologize. I've seen so many regulations. This one, I cannot remember the number and site, but there is that they must give us a report on all the claims that have been made.
Great,
Yes.
thank you.
And we will review those, especially in the beginning, and any patterns will definitely be brought in front of the commission for clarification.
Excellent, thank you, Sterl.
Thank you.
Anything further on parlays? Looking good.
But
All right.
I just wanted to
Commissioner
follow
Bryan?
up on Commissioner Skinner's question, Sterl, which is, you go from 2 sentences to 168 references. And you said, you understood it, you've got some level of sophistication. Is there anything in that 168 references that you feel really should, in an abundance of caution, be added to the licensee's house rule that only has 2 lines?
So a little background on that is that the licensee that had 2 lines, right, also
It's
is
not in front of
only
us today.
is not in front of us today. They are very limited and only offering 3 events. So when I say
Oh, there'll be a limit to their parlays too then, by extension?
Exactly, right?
Okay.
And so the one that had the parlay references, I found it fantastic that they could reference in that parlays with multiple different sports can go on at one time. And then they go into whether it's a parlay that is just on results or whether it's in-game parlays as well as that, right? So the detail creates the amount of information.
Right, so it's not necessary given their offerings.
Correct.
Got it. Okay, thank you.
Mm-hmm.
Anything further on parlays? Sterl?
Okay, so the next topic that I wanted to bring up is the addressing of obvious errors by a operator. So language that we have seen in which I would want to just bring to the attention to the commission is I will use one operator's definition of obvious errors. Licensee makes every effort to ensure that we do not make an error in prices offered or wagers accepted. However, If a result of a mechanical, technical, or human error, licensee offers or a patron places a wager in obvious error, the licensee reserves the right to either settle winning wagers at the corrected price or as reasonably determined by the licensee, or void any wager placed in obvious error. An obvious error includes, but is not limited to, the following: errors offered or placed on events after the outcome is already known. Wagers offered or placed on markets where incorrect participants are listed. Wagers offered or placed on markets where participants are incorrectly designated or listed in incorrect order, i.e., home team is listed as the way. Wagers offered or placed at odds that are materially different than those available in the general betting market for a given event at the time the wager was placed. Wagers offered or placed at odds which reflect an incorrect score situation, or wagers offered or placed at odds being clearly incorrect given the probability of the event occurring or not occurring at the time the wager was placed. We bring this to your attention because it is in the regulations. It is in 238.35, and it is in the House rules to address obvious errors to the patrons. We noticed that language is very similar to this in a multitude of our licensees. In one way or the other, they all address obvious errors. This though, it was brought to the attention because we want to make sure here in the Commonwealth that the patron has their consumer rights and are making sure that one is not being ignored or discarded. So I will pause there, and I might ask the commission to discuss what they believe is an obvious error, or however they would like to tackle this subject that was presented.
Can I ask a point of clarification? And forgive
Sure.
me, I woke up thinking about this and I haven't gone back through all the documents. But in our regs itself, as we think about obvious errors, or if it's not in our regs themselves, do any of the sports wagering operators presume that they can void a bet without commission approval?
So there are several areas in which obvious errors are addressed in our rules, and several errors that are addressed like without question. An event that has incorrect people that are in it and are all completely wrong, and people have wagered upon it, and it would be unfair to both parties. They are required by reg to void the wager. But
so,
there are
and they
several,
can do that. Excuse me, Cyril. They can do that without our approval.
correct. They would be following the reg as.
Yeah.
Go ahead.
How do you feel about that, Sterling? And when it's, I understand there's like the spectrum of obvious. And
Yes.
that's in somewhere there's something obvious, but I wonder about ever approving a void.
So a great deal,
without
a great deal of voiding and canceling of wagers, a lot of times will require to be done at a very expedited rate, right? More like once an error is known, you do not want to have your customers believing that there is that there is something, that they're in action when they are not, right? When they believe, the worst thing I could possibly think of is if a customer believing that they have a winner, right? And then after they believe they've won, they go to cash it, and then it's like, oh wait, it's voided, and they didn't, it seemed like it happened just instantaneously because they won. Now, That said, there are several areas in our regulations also that ask them to define obvious wagers. So in both 247
Obvious
and
errors.
Obvious
230,
errors, right? You mean?
obvious errors, yes.
Yeah.
Okay. So for that time, the time frame is very important for them to be able to void wagers and not have people hanging on, or especially if an error is found, offering 1,000,000 to 1 odds on something that is, we know to be an error, have to remove it, right?
So we have to get into what an obvious error is, but there, I am wondering, are there other jurisdictions that never allow for a bet to be voided without commission approval?
I can jump in here,
Thanks.
Chair, for 1 second. So the portion of the reg that we'd be looking at is 238.35, as Stroll pointed out, and there's a 2-tiered system for the canceling of wagers. The first tier is where an operator can cancel a wager without permission from the commission, and it sets out circumstances in which that can be done. A lot of them are very clear. The location of a game has changed. A particular player isn't going to play in that game. So there's not a lot of discretion there. It's a very clear thing. No discretion. And so I think, and I'm happy to share the language, but when it talks about obvious errors, I think it will be up to the commission to decide how much discretion is there. And we can talk about that. And then the second provision of section 35 is where, in all other events, before a wager can be canceled, the operator has to come to the commission for approval and explain why they wanted to cancel it, et cetera. And there's a process for that. So that's the difference. But that is the provision of the statute that you'd want to focus on in thinking about what an obvious error is.
Now I'm just going to give you some more background, everyone, as we think about obvious errors and the discretion, the exercise of discretion. Is our friend Dave Reebok called today on something else, and I told him, we're doing house rules, and I'm concerned about this issue. And his words were, no voiding a bet without your approval. So just keep that in mind. Now, he may not have known about these, the reg where we have the obvious, but he gave us, so from a good regulator said, I may mention you today during our meeting. So let's just keep that in mind. And I know we have operators here and they know Dave very well. So, and of course, Bruce, Joey, you know him well. So I just had a new subset question, Sterl, from our nice 2x2 as of yesterday. So now we have to think about obvious errors in that spectrum. Commissioners.
Yeah, so this is the biggest conundrum for me in these house rules. And even when I'm reading 238.35 and I go down and I look at things like the reference in, I think it's 238.
Can we put it up, please? Let's put it up because I was grabbing it right before.
I have a hard copy. I don't know if somebody has the.
No,
can share. I only have a hard copy.
If you give me 1 moment,
I have it. I can share it.
Okay.
Excellent. Yeah.
So I can, for the sake of expediency, I can tell you conceptually.
It's good here. If you could just make it a little bit bigger. Just hold on, Commissioner Skinner, Commissioner O'Brien, just for 1
Not
minute.
enough?
A little bit bigger, please.
Sure.
Oh, wonderful. Thanks.
So which section?
So I think it's 1I. And it talks about obvious error, and then there's 4 enumerated circumstances.
Yeah.
And I noticed in there, it said human error in the placement of the wager. And I know I conceived that as more human error on the part of the patron and canceling it in a circumstance where the bet hadn't gone through and the rules allowed them to do it. But it seems like some of the definitions of obvious error in the proposed house rules, I'm not really thrilled with, because it seems like there's just a lot of discretion on the part of the operator to cancel when they make a mistake on something. And I have concerns about that definition of obvious error and how it interplays with other consumer protection statutes like 93A. And I had asked this question basically as soon as I got the memo on this. And I know, Todd, you and I spoke briefly and have been looking into this because I have two layers on this. One is sort of there's the either illegal or factually impossible bet. And to me, those are obvious errors. You to your point, still, you place the bet after the conclusion and the results are known. That's an obvious error. It's an illegal bet. A college basketball game is bet on in the Commonwealth of Massachusetts on a Commonwealth team. That's an obvious error. It never should have been allowed. Those to me are obvious errors. You know, this concept of materially different to what's out in the market at the given time, whatever, that's kind of subjective. And I think about other circumstances with other people in commerce where if you make an offer by mistake, you're bound by the offer if a consumer accepts it. So 93A covers it, the federal statute that covers it. And I think the AG's letter, they submitted it to us yesterday, they flagged this. So I want to have a detailed discussion about what obvious error means. I'd also like to have some language in there that makes clear that no matter the definitions in here, protections that might be available to consumers under 93A and the federal statute are still available, because I want to make sure that this is all being done in a way that's fair all the way across the board. So I thought of obvious error as
Obvious.
like a factual impossibility or illegal, not, geez, you know, you should have known that was a crazy odd, you know, whatever. Well, that might be expecting and demanding a level of sophistication on the part of the consumer that I don't necessarily think is appropriate. So that's where I'm coming from in the definition of obvious errors.
So Commissioner O'Brien, help me out, because this is our reg in front of us and they're working off from that reg. Where are we going with this?
Well, that's what I mean. When you look at incorrect odds and human error in the placement of the wager, I'm looking at that now and I have concerns about that.
So the wager,
because it seems to be, incorrect odds. Well, says who? All of a sudden you guys change your mind on the odds. I mean, I'm concerned about the level of discretion that's in 1 and 2. And to the extent that that's the reg right now, I'm looking for sort of language that makes me feel more comfortable protecting the consumer.
Caitlin?
Because I don't know, Todd, if you want to chime in, because I did ask Todd this, whether we were running afoul of anything else.
Well, that was where I started my questioning, to just see where we were on because I woke up thinking about it and then had that quick conversation right before the meeting. So I don't have anything further to offer from what New Jersey does on language. I didn't get a chance to do that, Commissioner. Caitlin and Todd, the wager, what we're looking for is the degree of discretion that the operator can exercise because what they consider obvious error to be. How do we reconcile this and help Sterl out in terms of assessing these rules and giving us guidance?
One of the things that I found to be helpful in my review was to look at the actual language in the various House rules, because I think what you'll start to see is that they tend to identify, 6 or 7 areas that are considered to be under their construct obvious errors. And I think some of them we might agree are obvious errors consistent with what Commissioner O'Brien just said. There are others that are less than clear, and those are the ones that I think can be refined. And so I think it might be difficult to just speak generally about what we consider obvious errors to be, and it might be helpful to look more specifically at the proposals and make individual judgments as to what.
Let's go through each let's go through each house rule on this, right, commissioners? Let's just get going on it. We have, what, 6 today? Should we look at them, the provisions, commissioners? Do we all agree? Pull them up?
Yeah,
Am
I don't know if anybody else had any thoughts before we did that, but
Well, I mean, we can do it and have our thoughts at the same
as
time,
we
but
go.
I think,
Yeah,
and Caitlin, unless you have, I want to just also turn to you. Do you agree with Todd? We should just look at the language. I wonder too, if there needs to be overarching guidance as well, ultimately, so.
yeah,
So this is
Yeah.
what I'm thinking, and I of course agree with Todd, that it makes sense. What the commission is here to do today is to approve or disapprove the house rules, and so going through each house rule is completely within your purview and appropriate. What we can then do is from this conversation, take that guidance and parameters into account, and we can come back with proposed revisions to 238 that would encompass sort of what we're talking about here today. So it would be a 2-step process.
Okay, excellent. And so when I say the house rules, I know that you've got the notations, Sterl, of which apply to just obvious errors. And there's going to be multiple sections. Let's do, but Sterl, you were up, and I've got Joe raising his hand. But beforehand, Sterl, just to complete my thought, I was thinking we would do it in alphabetical order, and you would basically scroll down to the language. But let's turn to Joe. Good
I just want to
afternoon,
bring
Joe.
to the commission's attention that within 238.35 that the is it 3? No, wait, sorry, 8. A patron can request of the commission to review any wager declared canceled or voided by the operator. That is all.
Yep.
So
I was going to bring that up later.
Just keep that in
Joe.
mind in this discussion. Okay.
yeah. And I
Yeah.
also wanted to keep in mind, I don't want that to be deemed the exclusive remedy, that I don't want consumers to think that's their only remedy if they feel that they've been subject to some unfair deceptive practice.
Thank you.
So
Thanks, Joe.
Yes.
Thanks, Sterl.
thank you, Joe. If you would like, I have them all queued up in their sections of obvious errors. If you would like, I can go through each one unless you still have some discussions from the other commissioners that didn't say anything. Is it okay to start?
Oh, yes.
Okay. I'll share my screen.
Thanks, Sterl.
Yep.
I think this is the best way, right, commissioners? You're all okay. I see Commissioner Skinner. Thanks. I appreciate it. Commissioner Hill, you're all set with this approach too? Okay, good.
Please let me know if you can see my screen. I was having problems yesterday. Can everyone see my screen?
If you are able to make it just a tad bigger, you may not be able to.
Absolutely. Is that okay?
Yep, that's better.
Okay. So this is the definition from BetMGM. This is the one that I read to you all.
Hey, Sterl, I am here from BetMGM in case there are any questions on this section.
Thank you, Alex.
Thanks, Alex.
I want to take just this time while you're reading to thank all the licensees for their responses to all my questions that I had on the house rules. I greatly appreciate all of the communication and the quick responses.
Alex, what did you think about Director Reebok's advice to us?
Yeah, certainly that is the rule in New Jersey. In the jurisdictions we operate in, I would 75-25 percentage wise, I would say, so just a rough estimate as to this 75%, I would say do allow for voiding for obvious error without seeking prior approval from the regulator. There are jurisdictions that do require prior approval. New Jersey, New York. There are a few others. I have an internal list of that. But there are also many jurisdictions that do allow us to void for obvious error without seeking prior approval. And a common practice would be for us to notify the regulator so that they're aware of the voids in case any patron had an issue with the practice.
And so when you're dealing with those jurisdictions like New Jersey and New York, does it really cause delays?
It certainly we follow the process in whatever jurisdiction we're in. There is a significantly longer process in states that do require prior approval, but we will follow that process if required. And I will just say, in terms of the language that we have here, this language has been accepted in all jurisdictions where we operate in terms of our definition, but certainly understand there's specific considerations for each jurisdiction that you'd have to take into account.
Well, I must say he went wider than I expected, but I do value his judgment so much. So that's why I wrote down the note. It was pretty emphatic. So let's see.
So the fourth and the sixth bullet down in the first cluster, in the first section of bullets, is the ones I have I'll be honest with you, Madam Chair, knowing that New Jersey and New York do it that way, and particularly as we're in the infancy of this as regulators, my preference would be it doesn't happen unless we say, okay, and that would require a reg change, I realize, but that would be my first choice. As for how this is written now, the fourth and the sixth are the ones that are most troublesome to me. This sort of seems subjective, sort of materially different from those available in the general market at any given event, time, clearly incorrect given the probability of it. And Stroll, maybe you can educate me in this, and it's not as much of an issue as I think number 6, but those to me just seem like rather subjective exceptions to canceling, which I have a lot of concerns about.
I agree with you. I agree that they could be subjective. We would hope that we would hold our licensees to a high standard, but we also want to assure that all of our patrons are protected in all their rights. That said, I agree with you that those two could be have an area of weakness as well as 5. So the wagers offered at place of odds are reflected of an incorrect score situation. I just want to give the example that you might see in another operators is a team is winning 3-1 in a scenario with 2 minutes left in a hockey game, and they're winning 3-1. And the operator accidentally offers the underdog odds to the current winning team. So they would void that wager if that happens, or change the odds to reflect the proper pricing for that. That said, if they made that error and by some miracle, that team that was the underdog then comes back and wins 4-3, are they refunding or correcting the mistake made by the operator? That's the only kinds of things where you would have to take into account where you could see it being possibly looked at in a negative light.
If I could, real quick, I don't mean to step beyond my role here. I will say that, at least speaking for BetMGM, we truly do not like applying this provision. We consider it a poor customer experience for sure to have this happen, and we require review from our compliance team before ever executing this provision of the House rules. So we do take it quite seriously that we aren't abusing the definition in any way that would negatively affect a customer beyond what we view would do. It's truly obvious from the perspective of a patron placing the wager that there was an error in the terms of the bet that they placed. So I just wanted to put that out there.
That's really helpful, Alex. And you shouldn't feel apologetic. It's very good that you're here today, and we appreciate that. So thank you for chiming right in. Commissioners, questions for either Alex or Sterl? Maybe what we should do is maybe put this in the parking lot and then go to the next, just so we can do a comparison, okay? Unless there's a particular question on BetMGM. Okay, let's go on to the next one. Thanks, Alex.
Yep, I'm just loading it. My computer, of course, my computer is slow at this very moment. It's saying
That's
I have low resources, so I don't know what that means.
Sterl looked like he was turning right to Karen, Executive Director Wells. Low resources. If I could read a virtual platform, that was very funny. We don't normally have a loading problem. So, but these are long documents.
So this is, if I go out of alphabetical order, I apologize. This is Caesars.
Okay.
Caesars lists their errors in this way.
Yeah.
Madam Chair, through you. Sterl, could you make it bigger? I'm sorry.
Yep. No, absolutely. Just please state when you can't read it, and I will try to increase this font size.
So it starts with number 13. Do you see
Correct.
that on page 5, right?
Yeah.
And then we'll have to scroll down, and once we look at it.
Yeah, just let me know.
Okay.
I mean, the first 3 out of the gates on this are probably, or 2 reiterate 4 and 6, and then number 3, this, gee, we made a mistake, and therefore we're going to cancel. I don't know of other people that put pricing out there and stuff and have a consumer accept and then get to say, "Soup, sorry." So that's when I think 93A. That was my big question on 93A. Is I just don't know how that's possible.
But just to let the commissioners know, Kenneth is here from Caesars if you have any questions for him as well.
Commissioners, thoughts on this?
My other issue, honestly, is right out of the gates. They basically say this isn't the exhaustive list, which, if they're supposed to specify, then.
So maybe we should just let's put down the screen again. Commissioners, let me take your temperature. Sterl, thank you. I mean, I think what we're seeing is that there's different exercises of discretion, and that's really what this is about. I see Craig. I don't know your last name, but I see you shaking your head. Where are you from, Craig?
Good morning, Madam Chair, Commissioners, or afternoon, I should say. I'm the Trading Director for Caesars. Happy to answer any questions.
Thank you.
Obviously, in sports betting, there could be a comprehensive list of different ways an error can be interpreted. We always work with the regulator in instances where if we feel the error is significant and there's no subjectivity to it, we would work with the regulator, part the wagers, and then give all the relevant information to yourselves for you to make a decision therefore.
Thank you. That's very helpful. So Commissioner Maynard.
Thank you, Madam Chair. After hearing Commissioner O'Brien and you, your conversation with our friends in New Jersey, I think as early as we are, like we said the other day with the issues that come up, we're in its infancy. I think that I would be more comfortable looking at these before they're voided, period. And, as we go on, I think naturally the commission will start to draw lines, and those lines can be incorporated and adopted into the regulations moving forward. But I tend to think that the safest route, I do not feel comfortable drawing lines here today on the fly for each operator. So I would want to draw these lines as they come to us. And Sterl and I, in our 2x2, engaged in a number of different hypotheticals, going from the one he gave today to what if an operator really does accidentally put 1,000,000 to 1 odds on something for a millisecond, and someone gets it. And I think we can draw these lines as we go, but that would be my preference, I think.
Sure. O'Brien?
Yeah, I mean, you came out of the gates with how New Jersey does it and the recommendation. And quite frankly, after my briefings, that's how I entered this conversation. Is I think it's the better practice, particularly right now when this market is launching for the first time in the Commonwealth.
Commissioner Hill or Commissioner Skinner? What do you
No,
think?
great. I agree.
Okay, Commissioner Skinner?
So I share Commissioner O'Brien's concerns, just that, I want to make that clear. I had the opportunity also, as I know many of you did, to sit down with Sterl and Bruce. And this was, one of the most concerning issues. So I just appreciate Commissioner O'Brien raising the issue and speaking really, point for point on why, we need to be paying more attention to this. I am like Commissioner O'Brien and Commissioner Maynard, and I think I heard Commissioner Hill voice his agreement, is that I would rather, just given the time constraints that we are under, and I hate to say that, right? We don't want to interfere with launch on Friday, but I don't think that there is the time allotted for us to go through these and sort of make decisions on the fly with respect to what's already contained in the House rules. So I would like to see that all of the voids and cancellations come before the commission for approval. And I'm really pleased that we wouldn't be the first jurisdiction to do that.
Well, we do have time if we want it. So I just want to point that out, right?
I
mean,
understand that, but that would
Okay.
require a postponement of Friday's launch, and I don't think there's much of an appetite for that. Right?
Okay. Anything else? So I started with the reg because the reg does contemplate and that the sports wagering operators could exercise some discretion. That's why I went back to the beginning. We have already had the situation where we've passed regulations where there's unforeseen consequences. The sports wagering operators have done the right job by submitting the House rules according to the reg. I did, before I go on, I see that Stephen
Bomo, yes.
Thank you, has come in. I want to give you the opportunity to speak. Can you just remind me who you're representing?
Yes, hello. I'm Stephen Beaumont, the trading director for DraftKings. And I just wanted to say a couple of words on this subject, if that's okay.
Yes, absolutely.
I fully understand the Commission's concern around some of the discretion or subjectivity to these rules. I want to point out that it's DraftKings' position to be very pro-customer. These rules are there for extreme circumstances, and we are happy to run anything by the Commission that the Commission deems to be subjective, and we would be looking more to ask permission to pay in the customer's favor rather than avoiding the bets. That's our general position. The rules are there more to protect us in case of something totally extraordinary, like the 1,000,000 to 1 chance. So I think I probably speak for most of the operators here, where this is something that we want to only use in extreme situations, and that we're more than happy to discuss any voiding with the commission before doing so.
Yeah, I would
Executive
echo that.
Director, oh, so sorry, go right ahead, Alex.
I
Then
was
I'll go to
just-
Executive Director Wells.
Yeah, I would echo that on behalf of BetMGM. As I said, we're happy to participate in that process if it's established. The only thing is what Sterl mentioned with the timing, but obviously getting it right and getting the right outcome for the customer is paramount over the timing. And there's things that can be done to place the bets on hold during the pendency of a review or whatever we would agree to at the time. So yeah, just wanted to echo that since I gave both positions when I first spoke.
And Caesars would agree with that as well. And also I would point to the House rules that after the definitions say that we would, it's subject to the approval of working with the regulator as well on any adjustments. So it's the same approach. You park the bet, we work with you. There's never intent to be unilateral in terms of approach. So we are in the same position.
So we didn't scroll down far enough. Is that right? We didn't get to the good line. Executive Director Wells.
So, Madam Chair, I just had a question for legal. I'm wondering, what I'm hearing from the commission is, at least out of the gate, it would be probably beneficial to the Commonwealth to have the commission oversee anytime the companies do not want to pay out a bet because of some kind of error. And I'm wondering, Todd and team, if that could be a condition of the operations certificate, say initially, say the first 90 days or first 6 months, that they all come before the commission, and that would give the commission some time to evaluate this and look at the reg and make any changes if necessary. I'm curious if that is a potential option.
I think that's an option. I think one of the other options would just be to grant essentially a waiver or variance from the provisions that allow the operators to void or cancel wagers. And we can pinpoint those and just in its place insert what would essentially be a temporary rule that essentially provides that no wager shall be canceled or voided without notice to and approval of the commission. And I think that seems to be agreeable on the part of at least all the operators who have voiced any opinion here so far. And it's entirely consistent with the rules, with the exception of the fact that the operators had some discretion. So there's two places where it appears. It appears not just in the House rules section, but also in the internal controls provisions. So if the commission is so inclined, there are two places I think that you would need to grant a waiver or variance from. And the first, we've talked about both of them, but the first is in 247. It's 247.07, paragraph 10. That's a provision that says that the operator may, in its discretion, cancel an accepted sports wager for an obvious error. And an obvious error must be defined in the system of internal controls. So I think that's an area where we need to insert the rule that says no wager may be canceled or voided without notice to and approval of the commission. And the second place is the one we were also just talking about, and that's in the internal control section. It's section 238.35. It's entitled Canceled or Voided Wagers. And you talked about this recently. And I would suggest that this is a list of instances in which operators were directed to cancel wagers without notice to the commission. It includes the obvious errors provision that Sterl and everyone were just looking at. So I would suggest that what it sounds like the commission would like to do at the moment is just grant a waiver from 238.35 in its entirety to provide that no wager may be canceled or voided without notice to and approval of the commission. And I think if you do that in those two cases, and Caitlin and others, I'll invite you to jump in if there are other provisions that I missed. I think that covers the waterfront here as far as ensuring that the operators seek the commission's approval prior to canceling wagers.
Can I ask a question for clarification?
Sure, Jennifer.
Madam Chair,
Afternoon.
Madam Chair, members of the commission, thank you for having this conversation about house rules. Can I just clarify, because we've seen circumstances where before an event occurs, a patron might come to us and say, I accidentally placed a wager. I meant to do it on another event. We might, out of courtesy, cancel a wager for a customer before an event takes place. We've distinguished cancellation as pre-event, void as post-event. And so I just wanted to clarify whether we would need to seek approval for those cases where we're accommodating a customer's request for a cancellation, not a void. Void post-event would always have the regulatory approval.
Good distinction, Ms. Roberts. What do you think, commissioners? I don't know if our regs reflect that, but
I was getting, have we defined cancellation versus void?
Not in that way.
So that would be something we would need to do.
And with nodding your heads to the operators present, is that the practice that you generally do? So sort of the cancellation versus void after bets, or are there times where you do in other jurisdictions have to get approval for even before?
I think there's another element to the cancellation that we would need to keep in mind here, which is the non-discretionary cancellations pursuant to the house rules, which would be something that's outside the control of the operators, such as a player prop on a player that doesn't participate in an event, or a weather delay or rain out, which are all set forth in the house rules. And there's no judgment or discretion in those. If LeBron James doesn't play in a game and a player's wagered on a LeBron James outcome, we cancel those pursuant to the house rules. So that would be another way that cancellation and void is distinguished, which is set out in the same section of the house rules. Those aren't errors; those are just non-discretionary cancellations.
Yeah, actually,
just a comment.
I think if
from me,
Caitlin could
Alex,
speak to the reg that actually addresses that.
Commissioner O'Brien, can you repeat? I want to make sure we have one at a time. Thank you.
There's another reg that addresses just the scenario that he was talking about. I think Caitlin was just about to get to that before we had some other comments.
Thank you, Commissioner. So yes, a couple of things procedurally. So I agree with Todd that the commission could waive the two provisions that he spoke about for the time being. While this all gets cleared up, that would be fine. But sort of talking about a little bit what Alex was speaking about there, there's a provision in 247.0311, and that requires that the operators that offer an unauthorized or a prohibited sporting event or wager category immediately cancel and refund those wagers. And so that's something that we would want to make sure that we don't waive. And that would be the instance of a collegiate game with a Massachusetts team that's not in a tournament is offered. That would need to be canceled right away. So we want to be careful. Alex may have been talking about a slightly broader category, but that one in particular, we'd want to make sure we don't waive. I also think procedurally, you probably would want to condition the house rules, and you could be very clear in your condition on the house rules of what is allowed and what is not with regard to approval for canceling or voiding waivers. And I will also note that in our promulgation, we have not been distinguishing between the words cancel and void. And so I just want to be clear that others, operators may be interpreting that differently, but we are considering them to be the same thing. So I would just be careful about that.
Yeah, so simply defining them in that way may cause other issues for us then.
Correct.
Got it. Okay.
Chair. So I understand the distinction between the cancellation and the voiding of wagers. Are there any other scenarios that we haven't covered? So we talked about the scenario where it's in favor of the patron because they made an error. They contact you in advance of the event. And as a courtesy, you might cancel it. We talked about, the non-discretionary cancellations. Is there a scenario where any of you as operator would be canceling a wager, sort of that is beneficial for you?
I mean, just.
I
have, yeah, excuse me, Alex Ursa's hand is up. Thank you so
Yeah.
much.
thank you for the time. I appreciate the allowing us to make some comments. So I think just on the first part, I wanted to say that, void and cancellation lead to the same outcome, which is the stake that goes back to the customer. So I agree. I think I don't want to create different names for them because the outcome is the same. I want to call out the scenario that other operators might have where a void happen. It's not discretionary. For example, with a player prop, a specific player to score a specific field goal on an NBA game in a specific quarter, and that player maybe is not playing the last quarter. So at that point, we would void the bet because basically the player does not have an attempt to score a goal, and there is no way to grade the wager as a winner or a loser. We could grade as a loser, but because he didn't play, we would void it. So that would be something that would happen automatically.
That strikes to me to fall into the category of an impossible bet.
Would you say it again, please, Commissioner?
An impossible bet, because there is no factual way for that bet to actually come to fruition if the facts on the ground are impossible. So to me, that's a category unto itself that I can see why you would want to do. So 247.03.11 with the unauthorized or prohibited and sort of the factually impossible bets, to me, need to be canceled or voided, whatever term you want to use. It's those discretionary ones. And I think to Caitlin's point, I think we want to keep that language in the reg. What we want to make sure is anything beyond that has to come to us before action is taken.
I appreciate that. I think we're all aligned. The other situation could be that the result is graded in a wrong way, and we would need to re-result. Basically, at that point could be like a void and then a re-result with the correct result of the bet. So I think that's also a situation where voids or resettlement could come into fruition.
I might need a for example on that.
2 minutes. I need just 2 minutes.
Okay.
My apologies. Thank you so much. Thank you, everyone. My apologies, just navigating a bit. Thank you. Okay, so Alex, you were just finishing up. Commissioner O'Brien, you were responding.
I said I would probably need a for instance on that last one. I didn't quite understand the scenario that he was describing.
Yeah, again, someone, basically a bet is graded as a win, and that was a wrong result. and then it's regraded as a loss, or the other way around. And I think again goes to each operator could decide if they want to regrade the winning bet as a losing bet. Usually, if a bet was graded as lost, but it's actually a winner, operators will address those because it's in the best interest of the player to receive their winnings.
And how would that happen though? How would you accidentally grade something the wrong way like that?
It wouldn't be like us, but I think other operators can give an example. Like the feed provider can provide the wrong result, like a player prop, for example. And I think you saw the example with Giannis the other week where there was some debates about his player props with the triple double, where it took NBA basically to clarify what happened in that game.
Okay.
I'm going to turn to Joe.
Alex said it right when I was about to say. So like the data providers have an actual technical feed heading into sportsbook platforms. That data does come from a source. It can be a simple like, was that an actual assist? Or one that's actually frequently debated is sacks on the NFL end. If a defensive player tackles the quarterback, there might be another defensive player there, and that could be considered half a sack. These are somewhat subjective on the individual league rules, and those get. I mean, it doesn't happen often, but those can come through the platform in differences, and therefore the actual real statistical result needs to be rendered appropriately.
Thank you. Sterling, back to you. You're asking for permission.
Yes, please. So I think what we're hearing, and please correct me if I'm wrong, I think we understand what Commissioner O'Brien is asking to see prior to them being void or canceled. As Caitlin said, we do not distinguish between a void or a cancellation. So we understand there is also language already in 238.35 that addresses certain types of areas that were brought up here already. So I believe for Ms. Roberts' question, they have the ability to void a mistake made by a patron. It states in 235 in the introduction, 238.35, that for any transaction where a sports wagering operator may cancel or void a wager with or without prior authorization of the commission, the operator shall submit a system of internal controls for voiding a wager and subsequent allocation of patrons' funds. Now, in the beginning, it says cancellation or otherwise validly placed wager by a sports operator shall be non-discretionary. Sports wagering operator shall only cancel or void a wager without prior authorization from the commission under the following circumstances. An event where after a patron has placed a sports wager, I think this is her question, a sports wagering event is canceled, postponed, or rescheduled. Or in the case of a wager in which a portion of the sports wagering event shall be valid or event canceled or postponed or rescheduled, the effective outcome of the affected portion will be determined. I apologize, that still isn't it. But that they have the opportunity, if the customer has made an error, to cancel that person's wager by the internal controls that was placed. Now it says it has to be a supervisor, but I am assuming they have supervisors available on their platform to approve those things. I believe what we're trying to do as a whole as the commission is to just not have something be subjective and not look or be something where we would come into question on the validity of why you would cancel that wager, if it was, a very slight mistake or whatnot, it seems just to the advantage of the operator, which we've all heard from the operators. They don't want to do that, but we're just trying to make sure it's cut and dry. And I'm sorry if that went long-winded. I was trying to grab that there are areas in our rules, in our regulations that address those types of areas.
So I'm going to turn to Alex and I'm going to go back to Caitlin because I know she's thinking about this, given the overriding concerns that have been raised by the commission and with Sterl's observation Is there a more tailored waiver that we should be thinking about for the time being, Alex?
I'll be brief because I know there's a lot to cover. I think that section, if you go down where Sterl was talking about, subsection J covers when a patron makes a request. And I think this section as a whole, 238.35, covers the scenarios that we've been talking about in detail. It would really, from my view, only be subsection I that the commission has expressed concern with, where this is a obvious error. It's the obvious error section specifically. And if that was given a waiver, I think that would probably fit within the discussion here. But that just by input there.
Isn't it ironic that obvious error? There's just nothing obvious about it, right?
Don't I spend a lot of time working on this? So I know what you mean.
Let's go to Josh. And if I'm sorry, Josh has got his hand up, so I'm going to turn to him. Good afternoon, Josh.
Good afternoon, commissioners.
Nice to see you.
My name's Josh. I'm an attorney here at FanDuel, and really appreciate the opportunity to join the conversation. I think I wanted to echo Alex's points. In particular, it sounds like the commission has some concerns about the discretion in the obvious error section. So if we wanted to maybe center this a little bit, I believe this was Todd's suggestion, but I think his suggestion was focused on, kind of a waiver of the ability for operators to void without approval for obvious error, and leaving the rest of those abilities still intact.
Let's pull up that section again, Caitlin, or whoever has it handy.
I have it if you want me to pull it up.
Thanks, Sterl. Thank you. Caitlin looks at me like, I hate it when she does that.
No, I'm happy to do. Sometimes it's hard to look at it and talk.
No, I think we can.
And I was thanking Alex. That was, for some reason, my computer jumped up, but it is here, that J section that I was saying when an error occurred. That such case, the writer will have to call a supervisor to cancel or void. That's what we're speaking to, those types of errors. So the section.
Let's go up then to the I. Yeah,
the I is right here. Yep.
Chair, before we walk through these, I thought maybe I could propose a couple of options, and that might focus sort of the walkthrough. So two things. One, these were approved. We could actually still change this reg today. If you actually wanted to change the reg before filing, we could do that today. What I would suggest we do is walk through the section 35, and the commission could decide this stays in, this stays in, this is in, this is out. It's about a page, so it would be possible, I think, within the time limitations. The other proposal would be we file as is. Legal could take a look at this overnight and come back with proposed waiver tomorrow that reflected the conversation today, because this is also on the agenda for tomorrow. I think it's two ways of getting to the same place, but whatever the commission would prefer.
I know we have another conversation, Sterl, just one sec. We have another conversation about a couple more items, so perhaps the second option makes best sense. I see Commissioner O'Brien nodding.
Yeah, I'm under time constraints myself this afternoon, so obviously my preference would be that, and to do it in a clear-headed way and get through what we can get through that's on for topic discussion today, and make sure what we're moving on tomorrow morning is sort of clearly thought out.
Okay, Sterl.
Yeah,
Yes.
plus if we change those, would that mess with their internal controls that are being approved by GLI as we speak? So that's just the other thing.
We would likely have to, just as with the House rules, there'd have to be a condition on it probably. Might also have to be a condition on the internal controls, but you're right, Commissioner O'Brien and Chair Justine, there's a lot of moving parts here, so we want to make sure we get it right.
Okay, and so just to revisit because I think Alex pointed it out, this is where we started, and then the conversation expanded to the entire section, but this is the obvious errors. And so the idea could be a tailored waiver to just lift section I, but I think, Caitlin, I would like to defer to you and the legal team to look at this entire reg and see where there's some implications with respect to the discussion today. Commissioners, what do you think about that approach? And then come back tomorrow with least
Yeah.
right now on this.
And also Todd mentioned 247.0710 also mentions obvious errors and cancel. So that has to be looked at too.
I see Alex thinking about that language right now.
Madam Chair, I'm on board with the proposal. I know you can't see, probably
Well,
can't.
now I
see.
can see you. Thank you for speaking. As soon as you speak, I can see. Thank you. Commissioner Hill or Commissioner Maynard?
I think that we've all agreed to how we're going to settle the issue. So it sounds like we're just figuring out how to button it down. So I agree with whatever it takes to button it down.
And do it tomorrow. Finish that up and move on. I think you've gotten our policy discussion. Commissioner Hill, you okay with that approach? All right.
So just to button that one up, that small piece, I think we'll have to amend the agenda for tomorrow just to include this. It's actually on the agenda for today to look at these regs, which is why
we put it.
The House rules piece is on for tomorrow, but amending the regulations is not.
Isn't this part of it though? Isn't this part of the House rules?
Part of it.
Well, part of it is, there's also internal control provisions. So if we're going to amend the regulations, we should probably just notice that.
Well, I have no problem amending our agenda. I think we're probably covered. Just send the language over and Karen and I'll take care of that. Right? And Trudy. So,
Yeah, if you send it to the three of us, Todd,
I think we're probably covered. But we want to be more so, even more so, then no problem. All right, so Sterl, I now forget what page I need to be on, but we're turning now to your next. I think I was looking at the House rules as we went along. So now back to your memo. You were bringing our attention to methods of calculation, I think, next.
You are correct.
Okay,
so we're at the methods of calculations. This topic was brought to you because there are, again, multiple ways in which the operators have placed the calculations of payouts. Just wanted to bring this as to everyone's attention. I'll just quickly share one operator's method, which is used by a lot of the operators. And it goes through the calculations of a money line, the point spreads, payoff, odds, parlays, and teasers. So I just wanted you guys to all note that the odds of a parlay are calculated by the multiple odds of each leg of a parlay, which we understand there can be multiple, but these are just the general payouts. We want to also stress to customers, if they are interested in detailed ones in which operators will go also through in their events, and if there are any kinds of differences, they should outline them in the events in which they are wagering on, right? And so there's several. So the statement that I wanted to make clear, and I'm going to stop sharing, is how DraftKings describes the payouts, the calculations of payouts, is that they use a decimal system. And I am not positive on the statement, but I believe that they all use a decimal system, which is used primarily throughout Europe, and that when the operators are discussing how to figure out your money line, they're doing it in the slang of the American sports wagering that they're used to. But that, I believe, is still used and calculated behind the scenes in a decimal way. So when you were reading your DraftKings one and they state that they do all payouts via decimal, don't think of it as them being short and not being descriptive. All of their payouts are done via the decimal system, where they are placing odds as just that. They're not doing 9-to-2 odds on an event. They're giving you 4.50, right? time's your money. We are not discussing better here, but that was just the other one that did something a little different. And we had that question that we discussed yesterday out to them. So we're in discussions with them on how they provide their calculations as well. Is there
And
any?
Sterl, to that point, just so it's not confusing why we wouldn't be discussing better, it's
Oh, I'm
only
sorry.
because we have a few sports wagering operators who will be coming back to us with their house rules because they're just launching a little bit later than Friday's launch date.
Yes, I'm sorry, I didn't say that.
No, I just wouldn't want there to be any mystery. So there's 4.
Yep.
Okay.
Yep.
Thank you.
But if there's any questions, I'm online. Alex is from Better here, so I'm happy to reply.
Well, thank you, Alex. Thank you so much again.
All right, so is everyone good with the methods of calculations? Okay, so we all wanted the last section to bring the attention to the commissioners was the procedures relating to pending wagers, in which case all operators treat this differently. So we just wanted to point it out. It was in your packet of all the different ways in which they meet this requirement, all looked at it in a different way. A recurring theme, especially with all our tethered and non-tethered category 3, is that there are pending wagers, but that most of them are not considered pending wagers because they're not a winning wager until the governing body, the rules make a game official. I know we were hearing from a couple of the operators how their provider might accidentally list a score in error. They made it official, but then that would be an error that was reversed. Here, they're just saying that there are no pending wagers because once a game is official, they then pay their customers. There is almost instantaneous time in which they will pay their customers' accounts. For all the different ways they settled it, it was in your packet under each house rule. Does anybody have any questions on this section? Great. So in a review, the sports wagering division has found language that we wanted to have corrected. All of the category 3s were in process of doing their house rules, so it was an easy fix for them. I wanted to let you know that also all of our retail outlets, if they needed to make a change, have made that change and were submitted in the packet. And they have to do with the penalty. So by statute, we're not allowed to wager on penalties, injuries, player discipline, or player review. So early in our process, we had this change, and then it was our understanding that several sports have penalty time, penalty kicks, penalty shots. These are a significant part of these events and are an accepted part of a game or a match, albeit hockey, soccer. And the belief that penalties such as the next play will be a penalty, as in football, offsides, whatnot. The player X will have 2 or more penalties in a game would not be allowed by statute. But the other different things is that we wanted to bring your attention and have clarification from the commissioners for all of our licensees is how a final score of a game could be decided by a penalty time or a penalty kick or a penalty shot. And in turn, some of these acts in these sporting events are the biggest part of that sporting event, right? So in a hockey game, if somebody is pulled down and it's a penalty and they hold their hand up, right? If the person had a chance of scoring against the goalie and he had no person in front of him, that in turn creates a penalty shot in which they have one-on-one versus a goalie and could be a deciding factor in the game. Do they have the opportunity to use that? Since that is a penalty shot, can they use that as a wager? As in soccer, there is red cards and yellow cards. We believe that you could not wager on how many yellow cards would be in a game if somebody would receive a yellow card. But we also realize that that's part of the game and there might be penalty time tacked on. So with that said, we are asking for the commissioners to just discuss the spirit of this regulation on the shot, the kick, the penalty run awarded in cricket or in any other types of sports.
Commissioner Bryan, you unmuted.
Just point of clarification, it's stoppage time in
I'm
soccer,
sorry.
not penalty. So
Good, sorry.
I think we're free and clear on that one.
All right.
And I don't know, I mean, whether it goes into all sports and you need different answers on all of them, but it seems to me there's a distinction between, as you said, to use soccer as the example, yellow card, red card, versus is this player going to make a shot that is, on the PK line and a PK shot? To me, that's different than, so the game consequence following a penalty is different than betting on the penalty itself. That's conceptually where I'm coming from.
Commissioner Maynard, you want to chime in? I was in 2x2 with you, and I know we had this discussion. Your thinking?
I think, yeah, very similar lines as Commissioner O'Brien. I think there's a world in which some fouls and penalties are part of the game, right? And then there's obviously what the legislation, in my opinion, was trying to tackle. So my brain goes to basketball, Commissioner O'Brien, that I'm sure it does, Commissioner Hill too. Obviously a foul in a basketball game is a part of the game, right? And I would never expect a free throw to come into play here, right? Or points derived from a free throw or a foul. Then there are the technical fouls, right? And fouls where, players are injured, and those are totally, to me, in the spirit of what the statute was trying to tackle. And so I would make a distinction between, fouls or errors that are part of the game or the competition, and then those that kind of go outside the pale of the game and the competition. And that's the way, Sterl, when we were talking yesterday, that's just the way that I'm thinking about it.
Commissioner Skinner, Commissioner Hill, do you want to weigh in? Commissioner Hill?
I agree with what Commissioner Maynard just said. It's very similar to the conversation Sterl and I had a couple of days ago, actually.
Same.
Yeah, I'm of the same. Look, I sort of think of there shouldn't be a bet that encourages behavior that will be a penalty behavior, but that it's okay to have a wager on the outcome of someone who does have a penalty imposed on him or her. So I think we're all aligned on this. What do you need from us on that? I know ultimately we have to have take action, but I'm sorry.
I think
go
that
right
would be
ahead.
okay. I would then just turn to Councilor Grossman as if this is clarifying enough that it would be okay just as is, or if there is something else needed.
Does that make sense to you, Todd?
Yeah, I know. I think that was helpful. I think we're okay.
I think that the legislature did a really good job thinking about this piece, right? It's thoughtful provision. Okay.
And so,
yes,
Madam Chair?
Oh, Commissioner Hill?
Yes. Let me just get myself together here.
Oh,
I actually,
were you thinking of moving right now? Because if so, Sterl might have been.
No,
Okay,
I was
thank you.
not. No.
Okay.
Actually, I was going over my notes and I noticed something back in section D, the method of calculation.
Okay.
And I'm sorry to go backwards instead of forwards, but I think it's an important question. And it was for better. And I think I heard there was somebody here that could answer a question from that company.
Right, and the only clarifying point is that he's happy to take questions today, but we won't be moving on better. Okay, great. Alex.
As long as we're having the discussion. In your rules, and this is where I'm having just bear with me. Section 4, where it says method for calculations and payment of winning sports wager. So I was a little confused. It says in the last sentence, if the multiplier is 5x, a $100 winning wager will profit 400 and return 500 to the player.
Yeah.
If I'm betting $100 and the multiplier is times 5, shouldn't that be 500? I don't understand why it's 400.
So the total payout is 500, but the total payout has two components: the stake and the profit. So $100 times 5, the multiplier is 500, and that has two components: the stake, which is 100, and the winnings, the profit, which is 400. And that's how decimal odds work. And we've been live in another jurisdiction for 2.5 months, and we had 0 complaints about the method of calculation. But if you want us to add more clarity around it, we're more than happy to add that in the House rules.
I think if you could put some clarity to that, that would be helpful to the consumer.
Okay, yeah, we'll definitely take that feedback. And we shared, I think we had someone from the commission actually reached out to us, and we shared some feedback back, but we'll share back later today proposed language there.
Thank you, Alex, and thank you, Madam Chair.
Thank you.
Let me go backwards.
Thank you.
And I do remember during our presentation to Better and Alex that they would take this multiplier approach, and in some ways for me it was simplifying. So thank you, but whatever clarity we need, we'll get that from Better next round, right, Sterl?
Yeah, the reason why I didn't bring it up is because Better is exactly in the next round. And just a little helpful hint to Alex and Better, Commissioner Hill brings that up completely correct. That was our concern, because although they're trying to make it very simplistic, it is all of the experienced bettors that I know assume when you see 5 times your odds out in your wager, you're getting 5 times and then your original investment back. So when they see that you're offered 5 times, they are going to expect $600, $500 for the win, and their $100 back. That's why we're questioning the way you state that to the customer. Just please make that very clear to the customer, and I'm sure you won't have any questions.
Yeah, we will do that. And I think also in the example we shared, like when a customer is placing a bet, they see also the potential payout. So
Okay.
they see there what's the potential payout, but we'll make sure, and I think we'll take your feedback to include that in the households. Thank you so much.
Excellent.
Thank you, Alex. And Joe, got your hand up.
Yeah, just really fast. I just want to say, Commissioner Hill, that would be a plus 400 line in American odds would be a 5 decimal odd. So that's kind of how to think. I know it's language is complicated, but that's how it works. So
thank you.
Commissioner Maynard?
I want to point out, Joe, that to your point, and I do remember from our GLI training some months ago, that mathematically, the way that Better is actually talking about it makes more logical sense.
Yeah.
Mathematically.
Correct.
We have a very Americanized way of looking at these calculations that I don't think is done in some countries.
Yes, as you know, I am 6'7" tall, and when I'm in the grocery store and get asked, and I say I'm 199 centimeters, people look at me like I have 10 heads. But most of the world knows what I'm talking about. Okay, that's all I'll say.
We didn't know you were 6'7" until we got to finally meet you, because
I'm 199
all
centimeters.
virtual. Yeah. All right. I would be going. That makes it hard for me to know. All right. So that's really helpful, because I do think Better's approach for some, particularly that are not accustomed to sports wagering, it might make quite logical sense. And I think that was one of the factors that they used in promoting their product. So thank you. But we'll turn to Better next round. Okay. I think we're then at the end of Sterl, all the issues you were seeking guidance from us on, correct? We've got the one outstanding for tomorrow. How do we pause? Is it best way to pause, Caitlin and Todd? Sterl? Go
Just
right ahead.
one, just one thing, since this is grouped in with the retail's adjustment, I just want to go over it. Does anyone have any questions with what the retail outlets submitted to the commission? They're all good with that? Great. And so we've reached the end of my presentation. I leave it to you guys.
Thank you. My apologies, Sterl, for,
No problem.
for not double checking. Okay.
I wanted to thank Sterl for doing a great job on this review. It was a lot of work.
Thank you, Bruce.
Yeah, and we thank Sterl for the 1,069 pages, give or take a few regs. So, all right, thank you, Sterl. Excellent job, and thank you, Bruce, for your leadership here. Now I'll turn to legal team. Do we pause today and in our reconvene tomorrow vote, or do we do a partial vote today? What's the best way? We had one change that Todd, that was being suggested from only one change at the very beginning. Do you remember? And you took a
Changes
note.
to the actual controls. I actually have two. I have the rounding one and then the round robin.
No, but there was also one individual.
Yeah, that's the FanDuel had the round robin language they agreed to
But
add.
yeah, the round robin. Okay.
And Caesars, I think it was Caesars, has that rounding language that they're going to need to adjust.
Right. Oh, but now I see Ms. Rankin. How are you?
I'm good, Chair. Good to see you all this afternoon. We do want to put on the record that we will be removing the round down, and we will either round up or not round at all.
Thank you. We appreciate that.
Thank you.
Thank you so much. Okay. So back to my original question, Todd, do we?
Yeah, can I just, Madam Chair, can I just seek a point of clarification? Was the inclination to amend the regulations altogether to reflect the discussion today, or to grant a waiver while we review it even further?
I don't know if we actually decided a preference. I guess maybe the waiver sounds more temporary in nature than amending the regulation, and if the commission's inclined to want to sort of assess this for a while, we do the waiver. Caitlin offered the other.
From my perspective, it's a matter of timing. If we wanted to amend, we would have to do it today, get the approval today so that we could get it filed tomorrow. So given that we have a hard stop, it might make a lot more sense to sort of file as is and do the waiver language, and then we can bring back an amendment in the future after the regulation is finalized.
Well, you have a quorum without me, so we're all on the same page. So if you need to go and do it the other way, obviously today, then you can do it without me.
And are you saying we have to do it today versus tomorrow?
For purposes of filing, actually getting the paperwork together up to the State House, I think it would be cutting it very, very close to do it tomorrow, and we do need these in effect.
Okay, that I wasn't making that distinction, so thank you. I just want to check on Lisa. Your hand is still up, but do you have another question?
Sorry, I don't. I'll get that back down.
That's just will come down on its own then. Thank you. Well, I think commissioners weigh in here. Do you like the
I
idea?
think my preference would be to change the reg, to have it within our discretion, and then when we feel comfortable, we come back and change it, as opposed to having a temporary suspension of the process. I think that would be the better practice, even though I might not be here for the vote, depending on the verbiage.
Well, we certainly have had waivers with a time point on with respect to others. But so I agree that it's not my preferred practice to have regs attached to a time frame. But anybody want to weigh in? Mr. Skinner?
I think that just having I would want more time to digest the proposed language. I mean, I know, we can and we've certainly done business this way before where we're making suggested amendments on the spot, but it really does help to, review the amendments, sit with them for a little bit, even though it won't be long if we're talking about tomorrow, but just sit with them for a while and then to fully digest them before we come back to them for a vote. So my preference would be to issue the waiver on those two provisions that had already been referenced, and then spend a little bit more time on whatever amendments might be necessary. And I think the time frame for these to come back to us was how long? Was it 60 to 90 days, or that was on 152? Sorry.
So this is this will be filed for final promulgation tomorrow, and so it's a couple of weeks, Carrie, right, before it's final, and we could start on an amendment.
So this would be filed by emergency tomorrow, and then the emergency would publish March 31st, and then the final version would publish April 14th. So ideally, you would change it after April 14th. So we didn't have multiple versions in the same register.
Yeah. Bottom line is I'd love the additional time to consider any amended language.
I think it also will give us some input, some data, right? How often does this happen? And so that actually is a pretty good time period. I could be persuaded either way, quite frankly. Commissioner Maynard.
I'm sitting here thinking the same thing. Part of me wants to say that what Commissioner O'Brien says is very persuasive, that if we can just get it fixed and get it out there. Oftentimes allowing more times for comments is good and very helpful for us. So I'm kind of like you, I could be persuaded either way, but I think it sounds like we have two good options and 0 bad ones.
Commissioner Hill?
I am all right with moving these forward, getting the waiver for the two provisions and bringing language back at a future date so that we can have a further discussion on this and we can hear from other parties about the changes that are being made. So I'm okay moving forward today and putting in the waiver.
I think we're going to vote on the waiver tomorrow, yeah?
Tomorrow.
Yeah.
Well, I think that works if we aren't amending.
If we're doing the
today.
waiver.
We could do the
Right.
waiver tomorrow, Caitlin, right? So does that mean that we suspend the approval of all the House rules until tomorrow, correct?
I would suggest that.
But we just don't vote.
We just no voting, right?
Right.
Not today. We vote on them, address the waiver first, and then, a couple of tweaks on the House rules themselves. And the reason why we are not doing the waiver now is because legal needs a little bit more time.
Yes, I just want to make sure we're catching everything.
Okay, I agree. All right. So does that make sense, Commissioner Hill? We roll it over to tomorrow. It should be relatively swift, unless somebody thinks of some questions. To the operators, we really appreciate your patience as we navigate this, working to get it right and to reflect the values that this commission has pretty much been unified in throughout the course of our discussions and decision making. So I've got something from Josh. Josh Mehta, nice to see you again.
Madam Chair, I appreciate it. Like mine computer froze. Can you hear me at least? Oh,
yeah, we can see you too now. Thank you.
Great. I just wanted to ask a point of clarification. We think the operators understand their House rules need to be approved at the commission. With the commission taking this approach, would you like the operators to resubmit, with some consideration in the obvious error section, or would the intent be to approve prior to, kind of the commission taking any action?
That's a really important question to ask because we are lifting this. Now, what do they need to do with respect to the House rules? Legal? Do they take out all references to obvious errors, or how do they navigate this?
Well, it seems to me there's a couple of things. The two operators for whom there are specific amendments can make those adjustments. I think those have been pretty clear. The other one, and Caitlin can jump in here too and modify what I'm about to say, but I would suggest that everyone, I think, is clear as to the direction this is going, that with the exception of the obvious errors, the regulation will stand as is. And for obvious errors, any cancellations or voiding will require commission approval after notice. So I think that the licensees can begin to make that adjustment in their house rules so that they can be submitted shortly after the amendment's made, so we can approve them in short order tomorrow.
After the amendment is made, it.
Well, let me modify that.
The waiver.
After the waiver. So, I mean, to the extent the edits can be made today and resubmitted, so the commission has them for tomorrow, I think that is ultimately what we're looking
for. Director Wells, does that work for you? I think this is.
Yes, and Bruce, those should go directly to Sterl, because he's the gatekeeper for all of the house rules.
Yes, that would be fine.
It's a reminder. Alex, Walter, please.
Yeah, just to confirm what the change would be. Our preference would be to keep the definition of obvious error in to provide notice to customers of potential ways that an obvious error could be defined, but then to add a provision stating that we will obtain commission approval before proceeding with any modifications to a bet. Would that be what you're looking for?
I think that works, right?
Yeah, because we didn't really dive into a deep dive on how we would want to change the definition of obvious error at all. And I think, and I don't want to speak for everybody else, but it seems like part of what we want is to see this in practice where we approve them and determine whether we want to make any changes to the definitions.
Great.
So an overriding, is it okay if they all make an overriding provision that any void or cancellation with respect to an obvious error would come to the commission?
Right, requires commission approval. Right.
And I want to make sure that Ms. Roberts is okay with that.
Yes, absolutely. Thank you very much for this conversation that addressed the issue I had.
Okay, good. And I mentioned her because as I said the word cancellation, I was thinking it might trigger another inquiry. So, so we'll just, does that work, Caitlin? It's kind of a
I think that works legally, but I would want to make sure that Sterl and Karen were okay with it procedurally because it's going to be a lot more paper in to get to the commissioners for tomorrow.
So, and Sterling, you're raising your hand. Thank you for being so polite. The idea would be to give an overriding statement. You might want it up front, so that all the customers is clear that it will be commission approval. And to the operators, we will work nimbly as we can to be responsive. Is that fair, commissioners? If we're taking this on, it's okay. Sterling.
I was just, if there was clarifying language that would be for all that they could, just have a standard language, that would probably be very helpful to them.
That would be a good idea.
To include. And I received a note that there is one small error in BetMGM's reference. If they could just do that correction, they cite 238.51 and it should be 238.35.
Okay, we'll
Alex, you got that?
Yep, I'll make the adjustment.
Thanks, Alex.
Okay, so let's think about the language. I know Commissioner O'Brien, you're going to have to leave shortly, but I don't think we're going to be voting in any case, but a broad provision, because I think Sterl's got a really good point. Todd, Caitlin.
Could you clarify what language? Sorry, Todd or Sterl, I just missed it.
So it's I think the operators have it's a fair concern that if we could provide a single provision for the overriding provision of anything with respect to obvious errors, that none will be, no wager will be canceled or voided, whatever the language is, without commission approval. Could that be the language?
I think that would work something along the lines of the operator will not cancel or void a wager due to obvious errors without approval of the commission.
Prior approval or?
Prior approval.
Prior approval.
Does that work?
And then what reserves the right to seek such approval from the commission under the following circumstances, and then it goes into what they have each defined as obvious error.
Right, because I guess what you're saying is that
they're putting customers on notice that may happen. We just want them to also know nothing's gonna actually happen without our prior approval.
Okay. So there, he's giving a thumbs up. Caitlin and Todd, would you mind just memorializing that in an email to Sterl with Karen CC'd, and then that gets pushed out to all the relevant operators. Does that make sense? Okay. Are we good, commissioners, with that? To the those representing the sports wagering online operators, is there anything else that we can help with? And before we close today, I do believe that's our last item. I'll see agenda. There's nothing else. So is there, before we just close out our meeting with commissioner updates, and on this matter, I'm not hearing or seeing any other question from the operators. Well, then I think on behalf of all the commissioners, thank you so much. Your input was really helpful today. Already demonstrating what we know is that productive relationship that we have with licensees, and how very much we appreciate this kind of collaboration and cooperation. So thank you so much. All right, commissioners, with that, is there anything under item number 4, commissioners updates? Okay, Sterl, are you all set?
I'm all set. Thank you so much.
Excellent, thank you. And thank you, Bruce. Thank you, Crystal. And thank you, Executive Director Wells. And to the entire legal team, thanks for being on. Carrie, we brought you in, so thank you. All right, then I just need a motion to adjourn.
Move to adjourn.
Second.
I think Commissioner Maynard's got it.
His box lit up before me, yeah. Speedy.
He's there. All righty. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes. That's 5-0, and we look forward to tomorrow's discussion. Good work. Thank you, everyone. See you tomorrow. I think we start at 10 tomorrow. All right. Thank you. Thank you, everybody, for your patience with us today.